Lordship, with considering the other side, I beg to mention item 13, Lordship. It will be after 3 weeks, Lordship. I have to file my affidavit in this case, Lordship.
You are for the other side.
Other side, interim is there, Lordship.
Mr. M.K. Hussain, learned counsel for the petitioner, is present. Mr. N. Upadhyay, learned SC Irrigation Department, prays for further 3 weeks' time to file affidavit in opposition. Since the prayer is not opposed, same stands allowed. Let this matter be listed again after 4 weeks. Interim order passed earlier to continue.
Obliged, Lordship.
Yes.
May I please, your Lordship? I beg to mention item number 9, my Lordship.
Yes.
In matter may be reached the second week of February, my Lordship.
We'll adjourn it. How much time you want? Don't today it is listed, so you can make a prayer for another listing.
Yes, ma'am.
Only prayer you can make is for adjournment.
Yes, ma'am.
Adjourn for how long? On the prayer of Miss R. Begum, learned counsel, Mrs. R. Begum, learned counsel for the petitioner. Admission hearing of this matter stands adjourned for 3 weeks. Is accordingly.
Right, please, your Lordship. I'd like to mention item number 12, due concern from the other side. I'm from the petitioner in this case.
Yes.
Today I filed a reply to the IA for vacation of stay filed by the respondents. May I pray that matter will be listed on 5th of February, Monday, your Lordship. At that time, it will come on record.
You have informed the other side?
Yes, yes, yes. I've taken consent.
Mr. D. Borrell, learned counsel for the opposite party stroke writ petitioner submits that he will file his rejoinder. Rejoinder or affidavit in
Reply
reply?
to the reply.
Affidavit in reply in the IA during the course of the day, and therefore the matter be posted again after a week. Since the prayer is made with the consent of the other side, same stands allowed. Let this writ petition be listed again on 5/2/2024 along with the affidavit. Interim order passed earlier to continue.
Highly obliged, Lordship.
Till then, continue till then.
May speak the Lordship. Lordship, back to mention for listing one WPC, my Lord, for admission, my Lord. This matter relating to completion appointment, my Lord. In this case, DLC consider my case, but the SLC rejected, my Lord. I'm praying this matter will be fixed on 5th February, my Lord.
On third week of February.
Third week.
Third week of February.
Deeply.
May I please, Lordship? Lordship, I beg to mention for listing, Lordship, ordered matter, Lordship. Lordship, regarding Lordship, preparation of a seniority list, Lordship. Lordship, the
Third week of February. Yes, next month.
Lordship, can it be on the either on the 2 or 3, 1 or 2, Lordship?
Otherwise, what we'll do is all prayers for listing is allowed, but we'll ask the registry to ignore it and go by the ceiling. Because you are mentioning matters just like that for no good reason. Why you want this matter to be listed? What is the urgency in this?
Lordship, graduation list is prepared by the authority, Lordship. Lordship, the Chief Secretary directed all the head of the department to.
What is the urgency in your case?
Lordship, my case is pending, Lordship. I have selected the graduation list.
Third week of February. Yes, next
My
month.
pleasure, Lordship. I beg to mention item number 8, Lordship. Matter may be kindly for adjourn for a week, Lordship.
Item number 8.
Yes, Lordship.
You
We
are
have
for the
taken the
petition.
consent from other side, Lordship.
Who is for the other side? With the consent of learned counsel for the opposite party, the petitioners have prayed for adjournment of admission hearing of in this case for 2 weeks. On the prayer of the petitioners, this matter stands adjourned for 2 weeks. Yes.
Obliged, Lordship.
My pleasure, Lordship. In item number 24, Lordship, we are going to file affidavit, your Lordship. If you kindly allow us to call it for record, your Lordship.
Yes.
Obliged.
May I please, your Lordship? I beg to mention for listing pending matter. Pending matter.
Yes. Third week of February.
Obliged.
Lordship, I would like to mention a WPC.
Third week of February.
Third
Third week of February. Yes. These are not urgent. You are just mentioning it just like that. Your senior master told you go and mention before the court.
No, Lordship.
That is not the purpose of mentioning. Mentioning is to be made when urgent order is required. Any matter which does not deserve to be listed within 2 days is not a matter to be mentioned. Just because a case is pending, you cannot mention like this. Then we'll allow all mentions and ask the registry not to act on that. Don't do it. See the mention memo, what is written there. It is only for urgent orders. There is no scope for listing cases only because it is pending. Yes.
Please, your Lordship. Lordship, I beg to mention item number 20. Appearing on behalf of M. Sarania, Lordship. The lead counsel is due to some personal difficulty.
From the other side.
Yes, Lordship.
With the consent of the opposite party, the petitioner's counsel has prayed for adjournment of hearing of this case by expressing difficulty on behalf of the arguing counsel. Since the prayer is not opposed, same stands allowed. Let the matter be listed for hearing again after 4 weeks. Yes.
Obliged, Lordship.
Supplementary list for motion, I think.
Wait, please, Lords.
Yes.
But challenge is made to the order, my lord, dated 18/1/2024, my lord. Why is the petitioner dismissed from service, my lord, without holding the departmental record? This is my gist of the case, my lord. The petitioner was initially appointed in the year
Where
1990.
is the order?
Last page, 58 months.
Yes. So what is wrong with the order?
My lord, kindly peruse your lordship, page 49, my lord. They have initiated, my lord, departmental proceeding, my lord,
Hmm.
by issuing so called, my lord.
Right.
Without following that process, my lord, suddenly this order was
But
passed.
that
Without,
can be done. That is permissible under the law.
my lord. No reason has been assigned in the order itself, my lord.
Then we'll have to issue notice.
And this honorable court, my lord, as the Supreme Court has done,
He has been found
national
accepting
justice
bribe.
has
What reason is?
national justice has been violated. I have not been heard, my lord, when the order was passed.
No, he was found accepting bribe.
Say allegation, my lord, yet to be proved, my lord. And for that, my lord, he was suspended, my lord. Department proceeding was initiated, my lord.
Notice, we'll find it.
Till then, my lord, the order may be stayed, otherwise I may be allowed, the petitioner is directed to vacate the quarter, my lord.
You
He
have,
is a landless person, my lord.
you
Paid
have-
for employment.
what quarter? He's a masteral worker.
Master, he is given a quarter, my lord.
All right, till the next day, let him continue in the quarter.
In the
that's all.
quarter, my lord.
All right, I heard Mr. P.J. Sikal and counsel appearing for the writ petition also. There is the amendments made in the writ petition. The order dated 18/1/2024, by means of which the petitioner was dismissed from service without holding any departmental proceeding, is under challenge in the writ petition. Mr. Saikia, learned counsel for the petitioner, submits that no reason has been cited for dispensing with the service of the petitioner without holding inquiry. It is also the submission of Mr. Saikia that as a consequence of the order dated 18/1/2024, the respondents are insisting that the petitioner vacates the quarter which is under his government quarter which is under his occupation. Mr. Ardhar, learned standing counsel, PWD, Assam, prays for some time to obtain instruction in the matter. Issue notice of motion returnable on 6th of March 2024. Says Mr. Dhar has appeared and accepted notice. For all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned standing counsel so as to enable him to obtain instruction and file affidavit hard on the prayer of interim relief, having regard to the facts and circumstances of the case. As an ad interim measure, it is hereby provided that the petitioner shall be allowed to continue in the quarter till the returnable date.
Outline.
Allowed to continue in the residential quarter under his occupation till the returnable date.
Outline.
For at least one.
Yes,
May it please your lordship. My lord, our case is that my lord petitioners were initially appointed in the year 2001. They have passed all the tests, my lord, medical, physical, written. They were given, my lord, post number. They were given salary. After 5 months, my lord, they were sent for training.
Hmm.
After that, my lord, they were again tested physically and suddenly, my lord, they were discharged from service. Then we
Where is the
approached
order of discharge?
then
Where is the order of discharge from service?
Page 17 annexure 1, my lord.
But when they were discharged, they were still trainees.
My lord, they were enrolled, my lord.
Hmm.
They
I'm
were,
asking a specific question, please answer it.
my lord.
Where they were still trainees.
My lord, after 3 months, they became, my lord, permanent, my lord, as per rule, my
We'll
lord.
admit it and you list it for usual course hearing.
Yes,
You are not answering to the question of the court. You cannot get away with it. You have to answer the query of the court. Either you know and answer it or you don't know and take time. Two options are available. I am asking you, when they were discharged,
Yes,
were
my
they still operating as trainees or they were confirmed?
confirm, my lord, because as
Show me the
per,
order of confirmation.
my lord, as per rule, my lord,
As per which rules?
my lord, kindly see the rule. Assam for.
Yes, what is the, Miss Gayan?
Yes, my lord, that is the provisional appointment letter, my lord. That is, he was in training at that point, and his service was not confirmed. That is, my lord, that is specifically stated
But
in.
she's saying they were confirmed.
No, my lord, there is no specific order of confirmation, my lord. Let them show, my lord, confirmation order.
No, my
You
lord.
don't know whether they were confirmed.
No,
or
well,
not.
as
No, ma-
per, as per act, my lord, they are confirmed because if they have completed 3 months, kindly see the rule, my lord, or may I read, my lord? We are given
How
salary,
many petitioners are there?
6, my lord.
Which rule you want to rely upon?
Assam for act, my lord, kindly see rule 6, enrollment.
Yes. So if a person is enrolled, then what is the procedure of discharge?
My lord, they have suddenly discharged, my lord, without so cause
What is the
nothing. my lord.
procedure for discharge?
Procedure, my lord.
You're not aware.
Lord, they know, my lord, but my lord, they have illegally discharged us. We approach this honorable court, my lord.
What is the legal procedure? Tell me that.
They have to give me so cause notice, my lord. They have to give
Where
me.
is it provided? Is it
No, my lord, nothing, no hearing, no so cause. After enrollment, my lord, suddenly, my
so
lord.
when were they enrolled? What is the date?
Date, my lord, Annexure 1, page 17, 23/5/2001.
And they were discharged?
31/10/2001, after more than 5 months.
And during this period, they have received salary.
Yes, my lord.
What was the salary?
Everything they got, my lord.
Huh?
Salary, my lord, I have no, but they were
All right.
get 3 employee, my lord.
All right.
Yes,
Yes.
my lord, they are not required to file any so cause notice as per provisional appointment letter, my lord.
Hmm.
If you fail to successfully complete the recruitment training within the stipulated period, your service is liable to be terminated without any notice or assigning any reason.
Which
That
page
is,
you are reading from? Which
that
page?
is, my lord, provisional appointment letter of that year.
Is it there in the record?
Lord, my lord. Yes, my lord, that is in the. Visa provisional appointment. My lord, that is from their record, my lord, office record. That is their office record.
It is not in the record.
In-
The court will go by only what is there on record, not what is in your record. Gayan, you have to argue on the basis of what is in the case record.
Yes, my lord.
Which provision permits you to do that?
Appointment letter is. Provisional appointment 28. That is in 69/79 of the petition, my lord.
16?
69
69 of the writ petition.
of the petition. Sorry, my lord, 79, my lord. He was appointed in 2015, my lord.
All right, now please produce the records of medical examination. What was the finding? Let us see.
Medical examination.
So the petitioners were appointed pursuant to order of the High Court.
Order of the High Court in 2015, my lord.
All right. Now, how many persons were appointed pursuant to order of the High Court?
Person, my lord,
26th October 2014. How many persons were there?
one is my lord in 21, Talbir Singh.
Where is that order of the High Court? Is it on
Order of the
record?
High Court is my lord, page number 58, my lord. Page number 58 of the petition, my lord.
My lord, may I submit one thing?
Please take your seat. I'll ask you. So page 58, only one person is there.
Yes, my lord.
Where are the others? Only the 6 persons were appointed pursuant to High Court
Yes,
order.
my lord. Yes, my lord.
That is why you have terminated their service. How can High Court direct us to appoint them? Is that
No.
what has happened?
No, my lord, as per High Court order, we have implemented the High Court.
No, I'm asking you.
Yes, my lord.
Only these 6 persons who were appointed pursuant to High Court order.
Yes, my
They
lord.
have been found medically unfit. Is
Yes.
it?
Yes, my lord.
Not others.
No, not others. Only these 6 persons, my lord.
So we know what has happened. This is nothing but ego.
No, not ego, my lord.
We
That
will
is
not
the-
allow
that
you
is on
to-
record, my lord.
Huh?
That is on record, my
So
lord.
all these 6 persons have been found to be medically unfit, is it?
Yes, my lord. That is.
All of them were appointed pursuant to High Court order.
Yes, my lord. After my lord, High Court has given the order into as per page number, we have implemented that. Yes, my lord.
And everybody
again-
else has passed the medical test, apart from these 6. Is
Yes,
it
my-
so?
That I don't have the knowledge, my lord, whether everybody is.
No, then
Hmm.
you are the
But
counsel.
I am only on regard to the petitioners only, my lord. I am.
Uh,
Hmm.
that the whole thing is very clear.
No, my lord, that
This
is not
is
them.
this is done with a vengeance that will not indirectly will not comply with the High Court order. We'll allow them but terminate them after a few months.
Yes, but because of medical unfitness, my lord.
Hmm.
Medical
But what is
unfitness,
the medical unfitness?
that is there, my lord. That is medical.
So what I'm asking is only the 6 persons who got the order of the High Court.
Yes,
Only they were found medically unfit.
because my lord, we have done that medical test only for only for those 6 persons.
What was the unfitness, medical unfitness?
Medical unfitness is, my lord.
So we will ask them to appear before a board, a medical board in GMC, and if we find that this is wrong, serious consequential actions will follow.
My lord,
We can see a pattern here. This has been done deliberately. How can all
Because-
6 of them be medically unfit? And only
Medical-
6 of them medically unfit?
But I'll just take instruction whether only these 3 or these 6 or others.
Yes.
I'll take instruction after some time. my
12,
lord.
at
Yeah.
12.
Yes, my lord, at 12, my lord.
Come back at 12.
Yes, my lord.
Next matter. No, Ms. Gayan, who is the officer in charge in all these things? Who is the highest officer here?
Yes, so medical. Director medical.
We'll ask him to file an affidavit,
Yes.
but you find out what has
Yes,
happened.
I'm fine.
Yes. Yes, what is this?
My lord, in this case, they had appeared, the petitions had appeared for a recruitment proceeding.
Hmm.
And earlier, on not being selected, they had approached the Honorable High Court of Punjab and Haryana. There, my lord, want of territorial jurisdiction, it was sent back here. Now, my lord, our case was that per their calculation, the number of seats to be allotted to the state of Haryana was 6. They had appointed 4 persons.
Hmm.
Thereafter, 2 additional persons were appointed.
We'll
They-
admit it and post it for final
Yes.
hearing. Readings are complete.
Yes,
It
we
is
have filed their
complete,
affidavit, my
Yes,
lord.
madam, we have
On
filed.
an earlier occasion, this honorable court had noted that on the affidavit, they had not given my marks or the cutoff marks. And today, they were required to just produce
Do
the
you have the
report with
record?
card.
Yes, I have record.
So we'll post it for hearing then
Yes,
in
madam, I
April.
filed affidavit on additional affidavit on this, my lord. Can be done. Yes,
All
madam.
right, heard Mr. R. Majumdar, learned counsel appearing for the writ petitioner. Also heard Ms. A. Gayan, learned CGC appearing for the respondents who submits that some relevant facts were not incorporated in the counter affidavit filed on behalf of the department, and therefore she be granted 4 weeks' time to file an additional affidavit in opposition. Since the prayer is not opposed, same stands allowed. The petitioner would be entitled to further 4 weeks' time for filing rejoinder if so advised. Consequently, this writ petition is directed to be listed again on 8th of April as a fixed item.
I'm obliged, madam.
Item 3.
My lord, in this case, I am praying for sometime similar case with third party honorable court and judgment is reserved. So may come after 2 weeks.
What is the matter about?
My lord, disability pension, disability pension.
Similar matter, well, I don't know. Kuntu matter, Assembly. But I am not aware of the matter.
All right, Ms. S. Bora, learned counsel for the petitioner submits that similar writ petitions have already been heard by the learned single judge and judgment is reserved. Full stop. Therefore, awaiting the judgment in those cases, this matter be adjourned for 8 weeks. Mr. Gupta, A.K. Gupta, learned CGC appearing for the respondents do not have any objection if the prayer is allowed. Consequently, this matter stands adjourned for 8 weeks.
Item 4.
Record was called for, madam.
Record received,
Yes.
but all the records proceedings are in Hindi, my lord. That is about recording there, my lord. That was, that was I can, my lord. What is the matter about?
Dismissal from service.
Dismissal from service. These
That was
petitions are required to be admitted. Admission stage, how can dismissal for service be? I don't understand why every matter is listed for admission hearing only. We'll admit it. Dismissal for service. You have to file your affidavit. Yes, my lord. Give a fixed date for final hearing, that's all. We'll give a firm date for final hearing.
It's any date, madam, to your lordship's convenience.
All right, heard Mr. R.P. Sharma, learned senior counsel, appearing for the writ petitioner, also heard Mr. K.K. Parasar, learned CGC appearing for the respondents who submits that counter affidavit on behalf of the department has been filed and the records have also been received. Since it is a case of dismissal from service, the matter would require full length hearing. As such, admit the writ petition. Since the respondents are already represented, no further notice is required to be sent in this case. Office to list this case for final hearing as a fixed item on 4th of April 2024.
Can we be after 4th?
After 4th, you choose a date, please. You choose a date.
Yeah, after
No,
20.
you choose a date, we'll give it.
Madam, April.
And the request of Mr. R.P. Sharma and senior counsel. for-
April 30th, April, madam.
List this case again on 30/4/2024 for hearing as a fixed item.
Item 5.
May So Lordship kindly produce your Lordship order dated 8/12/2023, Lordship. This.
Yes, what has happened?
My lord, in this particular case, the petitioner's case is covered by the Upen Das's judgment, my lord. He is a casual labor who's seeking
No, Upen Das's case does not relate to people appointed prior to 1/4/1993.
my lord, but his case was left out at that period of time.
No, he has to be regularized. You conclude your arguments, we'll pass the order.
My lord.
You have already said he will be regularized. It is reflected in the order.
My lord, that page 60, there was communication between in the departmental communication wherein they have accepted that the date of his appointment was wrongly recorded. He was appointed before the cutoff date of 1993. So his case should have been taken into consideration.
What is the cabinet decision date? 25, it is 2005. What is the date of the cabinet decision?
Date of the cabinet decision.
There is an order, I think, passed by me this week only, Monday or other matter where whose case was dismissed in motion. Regulation matter, they have taken the order. Yeah, regular B Sinha was the lawyer. You have it? No.
No, not so.
My lord, but the
You should
question is
come
whether there
prepared,
is
huh?
a sanction post.
We are doing the work of lawyers also nowadays. We are not prepared. You want an order, but you are not prepared. Yes.
Lots of
Yes,
this
what is
order.
it?
My lord, the question right now is that whether there is any sanction post.
Doesn't matter. Create a superannuation post. You have to give this equal treatment to persons situated equally. That's Article 14.
14.
The writ court will have to interfere.
My lord, but
Our job is to see that there is no discrimination. Mistake committed by department is not his fault.
Yes,
but my lord, he has not annexed his appointment order, whether he has been
No, but you are agreeing that you admitted that he was appointed on 1/3/1993.
that what the department is saying, but they were considering the Upen Das's judgment subsequently because this communication, my lord, is dated 2005 and
Upen
No, this
Das's
order
judge-
is not for.
Please
in
take
the-
your seat.
Yes,
page
take your
60,
seat.
my lord.
Upen Das's judgment was rendered on a different context. That is when a claim was made that in view of para 53 of Uma Devi,
Yes.
people who have continued for more than 10 years, they should be regularized.
On sanction post. My lord.
Yes. But that the learned single judge allowed, but in the division bench, the state says that no, it cannot be done because 53 is an exception.
Exception, my lord.
And they are not appointed against sanction post.
Hmm.
So at that stage, the government agreed to give them minimum of pay scale and not terminate their services till retirement.
So he's also on non-sanction post, my lord.
Maybe, but 1/4/93 doesn't
Guarantee that he is on sanction post, my lord, because the
doesn't
rest,
matter. All before 1/4/93 were not in sanction post.
my lord.
So it is only
There
that
was a scheme, my lord, one-time
yes,
scheme, but he
so
was left out.
entitled to benefit.
He was,
He
my
was
lord,
left out because of a mistake committed by
mistake,
the
my lord, that
department.
is. But right now, as on date, whether there is a sanction post or not, as my lord has said, like
You have to create a
Create a-
superannuation post if necessary. You have to regularize these services with effect from the date on which similarly situated other candidates were regularized. Where is the admission by the department?
my lord, there's a letter at page 60 where they have admitted that there was a discrepancy in the
Page 6 of the writ
60,
petition.
my lord, 60
60.
of the writ petition. They've admitted that his date of joining was wrongly.
That is a letter by the director of Panchayat, is
My
it?
lord.
Have you got it? You are appearing for, Mr. Hendrik, you are.
PNRD, my lord.
PNRD. That is respondent numbers.
My lord, respondent numbers 1, 3, 5, and 6, my lord.
And Mr. Chakraborty, you are appearing for 2 and 4, is it? All right. So anything else? Anybody else has anything to submit? All right. Heard Mr.
My lord, may give me some time to find out whether he was appointed against the sanction.
No. Question doesn't matter.
Otherwise,
Can't go on dragging cases like this. How long you want him to wait? And he was engaged in 93. For so many years he's been working. That's not disputed. So you have to regularize it. Heard Mr. M. Sekal and counsel for the petitioner. Also heard Mr. P. Hendrik, learned standing counsel. PNRD Assam appearing for the respondent numbers 1, 3, 5, and 6. Stop Mr. A. Chakraborty, learned G. Assam is present on behalf of respondent numbers 2 and 4. The writ petitioner hearing was engaged as a master role worker under the law North Lakhimpur
Anshul Panchayat.
Panchayat,
Anshul Panchayat presently working as the in charge of Panigaon Gaon Panchayat.
North Lakhimpur Anchalik Panchayat
Under North
on
Lakhimpur Panigaon.
1/01/03/1993, and he is presently serving as
Yes, in charge secretary of Gaon Panchayat.
in charge secretary of the Gaon Panchayat,
Panigaon Gaon Panchayat.
Panigaon Gaon Panchayat. Full stop. The grievance of the petitioner is that although he has been continuously working as a master role worker, stroke casual employee since 1/3/1993, his services have not been regularized till today, as per the policy decision of the government, although other similarly situated candidates have been regularized. Full stop. Taking note of the grievance expressed by the writ petitioner, the respondents were asked to respond. A perusal of the order dated 8/12/2023 goes to show that, no, before that you write. From the communication dated 31/10/2005, issued by the Director of Panchayat and Rural Development Department, Assam, it is established that the date of joining of the petitioner was 01/03/1993, but while furnishing the particulars regarding the petitioner at the time of consideration of similarly situated casual employees for regularization of their services, his date of joining was shown to be 01/04/1993, as a result of which the service of the petitioner was not regularized. Full stop. It has been categorically admitted by the departmental authority that there was a mistake in mentioning the date of joining of the petitioner as 01/04/93, but although the actual date was 01/03/1993. Full stop. It is also not in dispute that since 01/03/1993, the petitioner has been continuously working as a casual worker. Full stop. Next para. It would be significant to note here in that facing with the problem of demand for regularization of a large number of casual employees, stroke master role workers, stroke WC workers serving in various government departments in Assam, the Assam State Cabinet took cognizance of the matter. Whereafter, where is the judgment of Upen Das? Is it there?
Lordship, think that's why it's not, I don't have a copy of it.
Markings on it.
Thereafter, there was a cabinet decision of the state dated, do you have the date of the cabinet decision?
No, Lordship.
22/7/2005, whereby a decision was taken to regularize the service of all master roll stroke workers stroke casual employees who were engaged prior to 1/4/1993. Full stop. Pursuant to the aforesaid cabinet decision, the services of a large number of such temporary stroke casual stroke master roll workers were regularized. Full stop. Although the petitioner was also entitled to the benefit of regularization as per the cabinet decision, his case was not considered for regularization as it was erroneously shown that the petitioner had joined as a casual worker on 1/4/1993. Full stop. Aggrieved thereby, the petitioner has approached this court by filing the instant writ petition. Mr. Hendick submits that although the petitioner was entitled to be considered and his services ought to have been regularized as per the cabinet decision, since he had joined prior to 1/4/1993. Yet at this distant point of time, 1993, but due to the mistake committed by the department, the same could not be done. However, at this point of time, vacancies are not available, and therefore the prayer of the petitioner may not be accepted. Full stop. Then you write, in exercising extraordinary jurisdiction under Article 226 of the Constitution of India, it is the fundamental duty of this court to protect every citizen from arbitrary and discriminatory treatment at the hands of the authorities. Full stop. Since the petitioner was admittedly engaged prior to 1/4/1993, to be precise, on 1/3/1993, and since there was a policy decision of the government based on a cabinet decision to regularize the services of all casual employees, stroke WR workers, stroke WC workers, stroke master roll workers who were engaged prior to 1/4/1993. The respondents ought to have regularized the service of the petitioner. Full stop. By not doing so, the petitioner has been arbitrarily discriminated against and deprived of benefit of the cabinet decision for no fault on his part. Therefore, the prayer of the petitioner cannot be declined by this court merely on the ground that there is no vacancy available. Full stop. Since the right of the petitioner is firmly established and his entitlement is not denied by the department, his services will have to be regularized, if necessary, by creating a superannuation post, by giving it effect from that date when other similarly situated candidates were regularized in service. Full stop. This writ petition is therefore disposed of with a direction upon the respondent authorities to take appropriate steps in the matter for regularization of service of the petitioner in the light of the observations made here and above. The exercise be carried out and completed as expeditiously as possible, but not later than 8 weeks from the date of receipt of a certified copy of this order. The writ petition stands allowed. Parties to be aware of first.
In this matter, the petitioner the resignation of the petitioner, purported resignation of the petitioner has been accepted by the respondents, whereas the petitioner had actually applied for discharge from service after 15 years of service. Now, the difference would lie that if it is a discharge, you'll be entitled to pensionary benefits. If they take it to be a resignation, then I'm not allowed to pensionary benefits. On an earlier round of litigation, my lord, this honorable court had sent the matter back for a reconsideration by the department, but the department stuck to its that they keep on accepting the resignation. One of their stand is, number here, my lord, if lordship finds a difference between discharge and resignation as per the rules and the law laid down by this honorable court, that resignation could, even if it assumed it to be a resignation, it could not have been accepted in the manner that they have done. Lordship had given an order earlier.
So what is the order of discharge?
There is no order of discharge, madam. They simply accepted my resignation and did not allow me to join. That lordship would
He has
find.
sought discharge from service, lordship. And accordingly, he was also explained the hardship he will face in case of his discharge from service.
Lordship would
But-
find it page
Just a minute,
87.
just a minute.
Lordship.
Where is his letter? Where is his letter?
My letter asking for discharge, my lord. That lordship would find at page 81. I'm sorry, page 80, my lord. Page 81. The Hindi version, my lord, that they have annexed in their affidavit in opposition. Running page 27 of the affidavit. Lordship has it?
Yes.
निधाई प्रणाली विषय से ये डिस्चार्ज जाने के सामने सविनय निवेदन है कि प्रार्थी बल संख्या स्वयंसेवक मजर लली को आज अर्ज इस प्रकार है कि अपने घरेलू समस्या के कारण इस बल से स्वेच्छा से डिस्चार्ज, इंग्लिश इट इज डिस्चार्ज, जाना चाहता हूं। अतः श्रीमान डिस्चार्ज निवेदन है कि दिनांक 22/12/17 से डिस्चार्ज भेजने की अनुमति प्रदान करें। Now the order which is accepted the discharge, lordship will find at page 87. Number so-and-so Cook Mazhar Ali of his institution has submitted an application dated 22/12/2017 for discharge from service along with undertaking certificate. Now, if lordship will come to the last paragraph, therefore, under provisions of contained in Rule 17 of the CRPF rules, resignation discharge tendered by so-and-so is hereby accepted. Now, resignation and discharge per the CRPF rules 16 and 17 also are two very different terms. When a discharge is when I complete a certain period, I can ask for it.
You're reading, just now you read from which page?
On page 87, running page 33 of the affidavit in opposition. The last line will show they have used the term resignation.
So it's a comedy of errors. First of all, your client made an error. And then why did your officer included resignation?
Lordship.
So
But
why should it not be treated as resignation?
Lordship, in his application, it is clearly sought for discharge, Lordship.
Maybe, but they have accepted resignation.
Under
That's
section,
what I'm saying.
under rule
First
7.
of all, he could have resigned. He asked for discharge.
Lordship.
Secondly, you could have accepted the prayer for discharge, but you treated it as resignation. So now you have to go by your letter. Whose is more important, his application or your order? Which should be given primacy?
Lordship, under rule 17, it is discharge is permissible on his request.
Where is rules? Let's see.
Rule
Once
17 of
the
CCS,
discharge comes in, I'll be entitled to
CRPF
benefits. It is the only.
CRPF rule 17.
What is the difference between discharge and
But a
resignation?
discharge is when I complete a certain period of time, and when I'm discharged, I am entitled to whatever service benefits I had. It is just like asking for a voluntary retirement. Whereas resignation, I lose all past services. That is the settled law. So the moment
they have discharged you.
they have accepted as a resignation, my every past service has been gone. I'm not entitled, I'm not being given pension, I'm not being given anything. On an earlier occasion, lordship had taken down this fact, my lord, in an order, and lordship had observed that this man has asked for discharge twice. Once he was taken back, the next time he's not being taken back. So he would not be a person fit to perhaps continue in the force. But if this petition is allowed, taking it to be a discharge, then, my lord, he would be entitled to the pensionary benefits. In another matter, my lord, lordship had taken that when the termination was set aside, but the man is not fit to continue, he will be termed to be have been retired from today and he'll be
At
only
the
under the
discharge,
pension.
you get all benefits.
Yes, my lord.
He has asked for discharge.
I have asked for discharge. They explained me that in 20 years, you will get all the benefits. You should not go. I said, no, I'm satisfied. Let me go home. So that accept it as a resignation. Therefore, I lose out everything. Now, if lordship holds it's a discharge and discharge also, they could not have accepted without my completing a particular term. So if lordship holds that I have completed the term and then I am gone for a discharge, I will be only entitled to the pensionary benefits. And that is all I'm praying for today because I also feel this man, perhaps what has been observed by lordship, should not be going back again and again.
Rule 17 is
Rule
it?
17 and Rule 16, my lord. Lordship will have both. If it is the same book, then page 19 perhaps.
Yes. Yes, please.
Rule
Madam.
17, lordship.
One of you, please. Yes.
17 I am reading, my lord.
Yes.
Discharge. Subject to the provisions of the schedule appended to the Act, any member of the force shall at any time before he completed 3 months service or after completion of the full period of service for which he is engaged, be entitled to claim his discharge from the force by applying to his appointing authority through proper channel.
Yes.
That is discharge.
No.
And if lordship will have a few pages prior to that, page 10, the schedule of the recruiting role is there.
Page 10.
Page 10, my lord.
Hmm.
Recruiting role lordship finds a schedule. Second paragraph, my lord.
Hmm.
Provided that if you wish to withdraw from the force, you may submit your resignation at any time before expiration of the first 3 months of service, but not afterwards. Until the completion of the period prescribed as aforesaid, the commandant may either accept your resignation or at the end of 3 months. Provided that the commandant may, if he thinks fit, allow you to resign at any time on your giving 3 months notice of your wish to do so. But this has been interpreted by this honorable court to say that if I put in a paper of resignation, then at least 3 months have to go and I have to be given certain sort of counseling before I'm allowed to resign. Here, my lord, my prayer for discharge and my acceptance is on the same very day. This has been held to be by this honorable court to be not a fit acceptance of resignation. Given all the situation, my lord, today the petitioner is only praying that if it is taken to be a discharge, I am entitled to the pensionary benefits as deemed fit by this honorable court.
There is an order.
I go.
Earlier
Yes,
order.
my lord.
Where is it?
My lord, that order lordship will 2 days prior to this, I had a call. It's a longish order. maybe.
Can you point out the date of the order? It is 24/1.
Yes, my lord. 24/1. Third paragraph, my lord. After hearing the submission of the learned counsel for the parties, this court is of the prima facie view that having regard to the conduct of the petitioner, more particularly the fact that he had admittedly submitted applications for discharge from service on as many as 2 occasions. And on 1 occasion, his prayer was allowed by the authorities and he was asked to join back. The petitioner had failed to do so. I am of the tentative opinion that the facts and circumstances of the case may not justify an order of reinstatement in the ultimate analysis. Mr. So-and-so submits that since there is no concept of voluntary retirement in this case, hence the petitioner's applications ought to be treated as an application for voluntary discharge. And in that event, considering the fact that he has spent more than 15 years in service, the petitioner will be entitled to partial pension under the provisions of Rule 49 of the CCS Pension Rules 1972. Thereafter, lordship would have the bottom paragraph. In Naresh Chandra case, lordship had held that when the reinstatement would not be feasible or is not good enough, then the person would have to be taken to be in service till the date of the orders of honorable court, and thereafter it is pensionary benefits, nothing else, no everything notional prior to that. My lord, given that also the petitioner would be satisfied. I have had a discussion with him. I had submitted this earlier also.
No, we'll clarify that it is an order of discharge. Just we treat it as an order of discharge. That's all. The order, impugn order 22/12/2017.
My lord.
That is the order, is it not?
Yes, my lord.
That will be treated as an order of discharge.
And my lord, consequences of a voluntary discharge would follow. My lord. That lordship would clarify. Otherwise, they would say that even on resignation, they have to give me a discharge certificate. A discharge certificate is always there. Now, if they continue to understand it to be a resignation, I will not be
That
benefited
will
in any manner.
clarify. It is a voluntary discharge. He has asked for a discharge. He has not resigned.
Lordship.
Then unnecessary, why create the confusion? He has
Lordship,
asked for discharge. He has mentioned
yes,
it in
he-
Hindi and in
yes,
English
sir, for
both.
discharge, Lordship.
So
And
why
as-
it was treated
As
as,
per my instruction, Lordship, since he has not completed the 20 years of service, Lordship,
that
he
we
is
don't
also
know.
not.
If
and
he is
there is-
entitled under the rules, he will get it.
And also, Lordship, there is no prayer in the petition regarding pension. He only sought for the reinstatement in service.
All right, all right. All right.
That was clarified in the last order that since that was not the exact prayer in the writ petition, he was to take her instructions.
So order is 16/4/2021 or 22/12/2017. There is some order in 16/4/2021 also. is
Yes,
it?
my lord.
What
That is when
order?
this honorable court had sent back for a reconsideration to them, whether they can allow me to join.
Not
Then they,
reconsideration for it.
that lordship would find at page 97, 96,
Yes. He was allowed to rejoin, Lordship,
95.
Yeah,
but
first
he
time
has
he
not
was.
joined.
Page 95 onwards, my lord.
No, there is the order of the court, earlier order of the court.
Earlier of the court, order of the court is there, madam. That will be with the writ petition, madam. But she could find it at page 36, my lord, of the writ petition.
Sorry?
36 of the writ petition, madam. Earlier order of this court.
So this is the second round of litigation.
Second round of the
Lordship, in the earlier petition, it was held that it is a disputed question of fact and it cannot be decided.
What is the disputed question?
Whether I
Lordship,
had
in
gone
the-
back to join or not. That
Lordship,
is the
yes.
Whether?
I had gone back to join or not, that is a disputed question is what was held and therefore they
Yes.
were required to
It
reconsider.
is-
But whether it is a discharge or a resignation was not decided. At page 36, page 37, it starts. ma'am.
Hmm. So we'll only clarify that the order dated 22/12/2017 is an order of voluntary discharge based on the application.
My lord.
That apart, no further relief, no relief.
Yes, Lordship.
Petitioner will not be entitled to any relief. as
Only,
before.
only, my lord, it also only observes that whatever benefits of a discharge flows, they will consider and give it. Whatever benefit, I'm not saying that this is the benefit of that.
Yes,
Any benefits following out of a voluntary discharge on 15 years of service, he'll be entitled to. That much if lordship observes.
Let's say, as per my instruction, half of the unleave he is entitled to and he will be, yes, Lordship, as per my.
We are
instruction.
not deciding his entitlement.
Lordship.
Huh?
No, Lordship, since they are paying for pension or other benefits.
If he's entitled, you have to give him. If he's not, don't give him. As simple as that. Why these things are taken so personally?
No, Lordship.
It's a huge force. Of course, you have to maintain a discipline.
Lordship, he has deserted the service 13 times, Lordship. And
All right, so he
overstayed
has
leave
not been
for 10
taken back.
times.
Nobody is asking you to take him back.
Lordship,
Then what is the problem?
since he has not completed the qualifying service, Lordship.
All right,
10 years
had
is the
Mr. R. Majumdar, learned counsel appearing for the writ petitioner. Also had Ms. R. Devi, learned CGC appearing for the respondent. By assailing the impugn order dated 16/4/2021, by means of which the prayer made by the petitioner, the representation submitted by the petitioner for allowing him to join back in service was rejected. The petitioner has approached this court for the second time by filing the instant writ petition. Full stop. The facts of the case in a nutshell are that the petitioner was originally appointed as a cook under the
Central Reserve Police Force.
Central Reserve Police Force. In which post he had joined on. Can you give me the dates, please?
My lord, in the year 2002, my lord.
Joined in the year 2002. Full stop.
They have done 22/12/17.
While serving as a cook On 22/12/2017, he
Submitted an application.
the learned judges, this is,
Yes. ma'am.
this is a page 20, page 80, this is the application, is it? 22/7.
Yes.
Application for it. Discharge.
Learned single judge is mentioned as resignation in the earlier round.
Yes, my lord, because at that point of time, my lord, the arguments were coming in that mind that it's a resignation, and his on that occasion, his prayer was to join back.
He submitted and Mr. Majumdar, page 80 is the voluntary discharge application.
Actual application. Because you find in English also, he has written discharge, both English and Hindi.
Submitted an application seeking voluntary discharge, within quotes, voluntary discharge by citing personal reasons, full stop. Taking note of the request made by the petitioner, his application was accepted by order dated 22/12/2017, full stop. Later on, the petitioner wanted to join back in service, but he was not allowed to do so.
Allowed, Lordship.
Huh?
He was allowed.
Was allowed, I had
On
gone there.
13/4,
And he was allowed to do so. However,
89 page.
when was he allowed to join?
My lord, by order dated 13/4/2018.
13/4/2018. Page
Allowed to
89.
do so by order dated 13/4/2018. But even thereafter, the petitioner again remained absent.
Yes.
Mr. Majumdar, this matter will have to be
my
admitted.
lord,
The
my lord,
facts are quite.
I did not remain-
Mr. R. Majumdar,
I-
and counsel.
I did not remain absent, my lord. I had reported.
So
They
if
say
he has joined back, the earlier letter goes.
My lord, they did not, my allegation is they did not allow me to join back. They say that I went there and I said, I don't want to join back. That
Yes.
was the disputed question of fact. That was the only.
We have to
disputed
hear
question.
this matter, full
Yes.
length argument.
Yes, Lordship.
The facts are twisted. It's not as simple.
Yes.
Argue, start arguing. It will take the whole day. But why these cases should be heard in admission?
My lord, probably not, but my lord, that was what was ordered, my lord. That is how we prepare the pleadings were coming. Otherwise, my lord, we're not hearing on any day, my lord, which.
Give us the
Convenient.
dates and facts. Let us see
My lord.
what has happened.
My lord, on 13/4/2018 by an order, they required me to go back and join with certain documents.
Start from the date of his joining in service.
My lord, he joined his services in the year 2002 as a constable cook. And my lord, on 22/12/2017, he filed an application seeking discharge from service. On the same day itself, my lord, the respondents have brought on record documents to show that he was given some counseling at page 82 and page 83, treating his application to be one of discharge. On the same day, at page 87, the discharge oblique, the resignation oblique discharge is accepted. Then, my lord, I made an application requesting them to allow me to rejoin my services.
When is that?
The application date is not there, but allowing that application by an order dated 13/4/2018, they allowed me to, the application is dated 10/1/2018, and on 13/4/2018, they allowed me to join back. Along with a sworn affidavit that I want to join back service without any pressure. Thereafter, I reported back on 2/5/2018 to join. As recorded in the earlier order of this honorable court, it is a matter of dispute as to whether after reaching there, I wanted to join back or they did not allow me to join back. Taking this into consideration, the Honorable Court allowed me to file an application before the respondent authorities, putting forth all my grievances. This was done, and by an order dated 16th of April 2021.
1 minute. That is by the judgment of this court, is it?
Judgment of this court, my lord.
What is the date of the judgment?
My lord, this judgment
10-2.
10/2/2021 in WPC 8893 of 2018. At page 38, Lordship would find the second paragraph.
Yes.
On the other hand, Sri so-and-so learned CGSE by producing the record submits that the present is not the solitary instance of the petitioner submitting resignation. And even in the year 2015, such a resignation was submitted, and after a long period of time, his prayer to rejoin was considered. Learned CGSE further submits that the conduct of the petitioner is wholly inconsistent, and there has been instance of desertion by the petitioner for a total period of 692 days. A fact which is disputed by Sri Mazumdar, learned counsel for the so-and-so. Sri so-and-so, learned CGSE further submits the petitioner being a member of discipline force, such inconsistent behavior cannot be accepted. And the post in which the petitioner was engaged was a very important post which affect the day-to-day functioning of the force. Learned CGSE further contends that there is no illegality or impropriety in the procedure adopted for accepting resignation. Sri so-and-so fairly submits that there is no allegation with regard to nature of duties performed by the petitioner as a cook, and the only allegation is with regard to inconsistent conduct and also desertion. After considering the rival submission, this court is of the view that questions of fact which are disputed in nature would be involved in the writ petition, and therefore it may not be proper for the court to enter into merits of such disputed questions of fact which may require adducing evidence. Therefore, without expressing any opinion on the inter se merits of the parties, writ petition is disposed of by granting liberty to the petitioner to submit a representation for his re-engagement as a cook in the respondent force. In the event such representation is filed, the same be considered within a period of 45 days from the date of receipt of the same. It is clarified that such consideration would be without prejudice to the earlier rejection order dated 17/9/2018 and would be on the merits of the representation. Now, my lord, I had submitted that representation at page 40 onwards, and their order rejecting it came at page 48 on the 16th of April 2021. At page 51 is the last relevant portion, para C. Having put in more than 15 years of service in the force, he is expected to be aware of the service rules. However, as observed and despite his inconsistent behavior, having put up request for discharge twice, his request for withdrawal of his application was accepted with the provision of extant rules, and considering his request empathetically. Therefore, the plea that he was not aware of what kind of document or paper he was made to sign is not acceptable, and his averments are afterthought. Furthermore, the other grounds put forth by him as his health condition on that day, that is 2/5/18, when I reported back, educational background, under metric, and ignorance of knowledge is not found tenable. Therefore, in the light of the above, after considering all aspects, the undersigned hereby rejects the representation dated nil in respect of.
All right. So challenging this order, you file the writ petition.
I filed the writ petition, my lord.
So as of now, you don't want to press the challenge to this order.
My lord, although there are grounds for me to press the challenge to say that it could not have, the resignation could not have been accepted in the manner, and I am entitled to continue in service. But my lordship has seen that he keeps on going for discharge or he overstays leave. Therefore, what had fallen from lordship in the earlier order, my lord, I had a discussion with him. He's agreed to it. He would now only go for the claim of a pension if that order is found to be illegal. Now, my lord, the manner in which the resignation was accepted, if lordship will kindly have their affidavit in opposition at page 828.
Page
28 of their affidavit in opposition, page 82 running.
Yes.
This is the undertaking they had taken from me on, lordship will find 22/12/2017.
This is not legible actually.
My lord, not the Hindi portion, my lord, just prior to that will be the English part. Page 8. Page 82 is the English version, my lord. Down below, Lordship will find the same date, 22/12/2017, when I had given the voluntary application for voluntary discharge.
No, now you please tell us one thing.
My lord,
If you press the challenge to this order,
my lord,
then the matter has to be fully heard.
my lord, yes.
If you give up the challenge, then we can confine the consideration only on whether that was an application for resignation or voluntary discharge and
Discharge, yes,
verify it.
But if it
But
is,
if you press that argument, then we'll have to hear and give elaborate reasonings.
but the manner in which it has been accepted, the resignation, settled by this honorable court, the resignation could not have been accepted in that manner. There's a judgment which exactly fits into this case. When he applied for a resignation, on the same day the resignation was accepted, by noting down in a register that it has been explained, that resignation was set aside.
For that, 3 months notice was required.
3 months notice
But
was,
for voluntary discharge, it is not required.
if it is held to be a voluntary discharge, then that 3 months would not be required. Now they accept it as a resignation. If that acceptance goes, him continuing
That
service
will
is what I was
clarify,
trying to.
that will clarify.
And if it is a discharge, then my lord, the consequential benefits of a discharge is what I would be entitled to, is all that would fall from lordship. That is all I
You apply for the consequential benefits.
Madam.
We'll ask them to consider it as per
Consider,
law.
yes, ma'am.
That's
Taking it to be a voluntary discharge, they'll consider my consequential benefit. Even that will do, my lord.
Otherwise, it is not in their prayer or in the lordship statement in the.
No, that's all right. We can.
Yes, Lord.
Key litigation, sir, Coxon. No, join back in service and therefore submitted by tolerant submitted an application dated 10/1/2018
My lord.
requesting the authorities to reinstate him in service. Full stop. On 13/4/2018, the said application submitted by the petitioner was allowed and he was asked to join back. Full stop. The case of the petitioner is that he had reported for duty. No, a case of the petitioner is that pursuant to the order dated 13/4/2018, he had reported for duty on 02/05/2018, but the petitioner was not allowed to join back in service. First up. The department has contested the said claim of the petitioner by contending that he had never joined back he had never reported back in duty. Full stop. Be that as it may, being aggrieved by the alleged refusal on the part of the department to allow him to join in service, the writ petitioner had approached this court by filing WPC number 8893 of 2018. First up, by the order dated 10/2/2021, the learned single judge had disposed of the writ petition with the following observations and directions. Page 38 of proper double tick to double tick. Next para. Pursuant to the order dated 10/2/2021, the authorities had 10/2/21, the petitioner had submitted a representation ventilating his grievance in the matter. The said representation was rejected by the concerned authority by order dated 16/4/2021, declining his prayer by holding the representation to be devoid of any merit. Assailing the order dated 16/4/2021, the present writ petition has been filed. Full stop. Questioning the legality and validity of the order dated 16/4/2021, Mr. Majumdar, learned counsel for the petitioner, has addressed elaborate arguments by referring to the provisions of Rule 17 of the Central Reserve Police Force Rules 1955, as well as the recruiting role within course the board, recruiting role, RECRUITING, ROLL within course. in the schedule of the rules, Mr. Majumdar submits that since the petitioner had submitted his application on 2017, seeking voluntary discharge from service, and in view of the fact that the said application was allowed on the same day, that is on 2017 itself, without the 3 months notice period as mandated by the rules. The order dated 2017 is illegal in as much as resignation of the petitioner could not have been accepted by the authorities on the same day in violation of the rules. Full stop. It is also the submission of Mr. Majumdar that while disposing of the representation submitted by the petitioner by the impugned order dated 16/4/2021, the respondents have failed to appreciate the circumstances narrated by the petitioner under which he had originally submitted the application for voluntary discharge, nor did they consider the fact that the petitioner had actually reported for duty, nor consider the fact that pursuant to the order dated 13/4/2018, the petitioner had actually reported for duty. Mr. Majumdar has, however, admitted in his usual fairness that the petitioner has remained absent from duty and had submitted similar applications for voluntary discharge on several occasions, as a result of which the authorities have held him to be unfit to continue in a disciplined force. Full stop. Contesting the said arguments, Ms. R. Devi, learned CGC, has argued that the petitioner is a habitual offender in as much as on a numerous occasions in the past, he had made similar attempts, first to submit his resignation, tender his resignation, and thereafter make a request for reinstatement, as a result of which the authorities have taken a firm stand in the matter, contending that the impugned order dated 16/4/2021 is strictly in accordance with the provisions of the rules of 1955. The learned CGC has paid for dismissal of the writ petition. Stop. I have considered the arguments made by learned counsel for both the sides and have carefully gone through the materials available on record. Full stop. From a reading of the order, impugned order dated 16/4/2021, I find that the authorities have elaborately dealt with the background facts as well as the contentions advanced by the petitioner's counsel before arriving at the conclusion that his representation was devoid of any merit. Full stop. There is no illegality or perversity in the findings and conclusions recorded in the order dated 16/4/2021. Full stop. I also find that it is the admitted position of fact that the petitioner had submitted several requests earlier to relieve him from duty and thereafter gone back on his request with a prayer to join back in service. Under the circumstances, if the authorities are of the view that he is unfit to be retained in force, there cannot be any disagreement with such conclusion of the authorities. As such, the challenge made to the order dated 16/4/2021 is found to be devoid of any merit and is hereby rejected. Full stop. Coming to the other aspect of the matter, raised by the petitioner's counsel. It is to be noted herein that the rules of 1955 does not envisage voluntary retirement within courts, but under Rule 17 of the rules, there is scope for voluntary discharge from service in as much as any employee after completing the requisite years of service can apply for voluntary discharge of service through proper channel. First up. On the other hand, if it is a resignation from service, then as per the provisions of the rules, the same can only be acted upon no, but it can be accepted forthwith. That's
Yes,
the
ma'am.
rule
But
says.
this honorable court
Notice is not required, ma'am.
in Biswajit Mukherjee has held that the 3 months period and the counseling
Hmm.
cannot go within a day. All that could not have been done within
It
a
can
day.
be
And
either accepted forthwith
My
or
lord.
at the end of 3 months.
Lordship
period.
will find the next proviso, my lord. The proviso below that, my lord.
However, where is the judgment? Give me.
Yes, my lord.
Counseling, where it is written about counseling.
My lord, that was sort of, I did not interfere, but it is their standing orders which speak of that counseling, all put it in this order, my lord. In the judgment. I'm sorry, I gave 2 copies, my lord. Lordship may like to have paragraph 5 onwards
Hmm.
at page 3.
However, in the decision of this court rendered in the case of Biswarup Mukherjee versus Union of India and others, third bracket WPC number 6356 of 2011, the learned single judge, while interpreting Rule 16 of the rules, has observed as follows in paragraph 5, paragraph 5 to quote Kuriman.
Lordship, in this case, Rule 17 has been followed, Lordship.
Relying on the said decision, Mr. Majumdar has argued that the resignation tendered by an employee under the CRPF cannot be accepted, at least without the counseling period, which cannot be accepted unless the same is preceded by a counseling session, which cannot coincide with the 3 months notice period. Full stop. The said aspect of the matter may not be relevant in this case since the impugned order dated 27/12/2017 itself mentions that the order was passed under Rule 17 of the rules. Be that as it may, a plain reading of the application dated 27/12/2017 submitted by the petitioner clearly goes to show that he had applied for voluntary discharge from service, and the word discharge within quotes has been mentioned both in English as well as in Hindi alphabet. Full stop. There is no mention of resignation in the said order, in the said application. The authorities have also mentioned about discharge of the petitioner in the impugned order dated 27/12/2017, but has also added the expression resignation, although the petitioner had never intended to resign in terms of the language employed in his application dated 27/12/2017. Full stop. Since the no, you're right, 27/2000. Full stop. Therefore, the impugned order dated 27/12/2017 cannot be treated as an order of resignation from service, but would have to be treated as voluntary discharge from service and oblique or discharge from service within the meaning of Rule 17 of the rules of 1955, as the petitioner had apparently never tendered his resignation, based on which he ordered it at 22/7/2017 has been passed. Full stop. Mr. Majumdar submits that since the petitioner has rendered more than 15 years of service under the CRPF, he would be entitled to certain pensionary stroke retirement benefits under the rules. Full stop. Be that as it may, since there is no prayer in this writ petition to grant any such relief, the said aspect of the matter is kept open, and the petitioner is granted liberty to approach the authorities by making appropriate application on that behalf. If such an application is made by the petitioner, the same be considered in the light of the observations made herein above, as well as the provisions of the relevant rules, and the grievance of the petitioner be redressed in accordance with law as expeditiously as possible, but not later than 3 months from the date of receipt of a certified copy of this order. With the above observation, this writ petition stands disposed of.
Obliged.
Obliged.
May I please, my lord, this case relates to the dismissal of the serviceman. Yeah, my lord, what happened? Petitioner was placed under suspension, my lord. Thereafter, my lord, departmental authority, my lord, and he was dismissed from the service. Thereafter, my lord, he preferred an appeal, my lord. But the whatever document being supplied to us, my lord, does not reveal, my lord, the appeal has been acted upon. Just, my lord, mere communication was been made, my lord. Lordship, kindly have a look the last page of the writ petition, my lord. It does not reflect, my lord.
So this is for hearing, final hearing today?
This is for admission, my lord. If your lordship want to hear, fix a date for hearing and the entire matter can be disposed of.
Agree on a date, both of you?
Lordship, because I'm widow, my lord, I'm having no buy, my lord. My husband also died. So in that case, my lord, I'll pray.
I am asking you, agree on a date. You come
Lordship,
up with
lordship.
all kinds of dramatics, Mr.
Lordship, lordship.
Or we are simple
Lordship.
English is not understood.
On 15 February, my lord.
No, March.
March.
I heard Mr. Jay Borbia and counsel for the petition.
On
Also
5th
heard
March.
Mr. S. Dutta Lanet's senior counsel appearing for the respondent number
My lord.
Bank
For the
officials.
bank, my lord.
on behalf of the respondents. First off, Mr. Datta submits that this writ petition is ready as regards service and pleadings and can be taken up for final hearing on any other date. First up. After hearing the submission of the parties, this court is the opinion that the matter would require a full-length hearing. However, the learned counsel for the respondent is not prepared for conducting the hearing of this case today. Be that as it may, considering the issues involved in this writ petition, the same is admitted to formal hearing on the request of learned counsel for both the sides. This matter be posted on 5th of March 2024 as a fixed item for hearing. Parties to come prepared accordingly.
May it please, my lord. My lord, issue involved in this writ petition is regarding age of superannuation of the petitioner, who is a professor under Miyo Kumar Das Institute of Social Change. My lord,
We'll admit it and fix it for
lordship,
hearing.
petitioner will be attaining 60 years in the coming month, my lord. Some urgency is there. So, my lord, issue is very short, my lord. My lordship, I humbly pray for my lordship to take up this matter today, my lord. Otherwise, matter will become infructuous, my lord. Filing of this writ petition will become infructuous. In fact, my issue is whether the petitioner and the authorities could have discriminated only on the ground that he is a professor of an institute, which is not an educational institute. In fact, lordship is aware, my lord, the age of superannuation of across all the professors has been increased to 65 years. And that decision was also put to challenge. And your lordship passed the order affirming that decision, whereby age of superannuation was increased to 65 years. And pursuant to that, my lord, the institute, the petitioner, is claiming that the same benefit should be given to the petitioner, but that has been rejected.
Why it has been rejected?
Only, my lord, they have filed affidavit, and the only ground taken by the authorities is that the institute is not an educational institute, so it's a research institute. Therefore, although he is a professor, he is not entitled to get the age of superannuation of 65 years. That is the affidavit on stand, my lord.
Who has filed the affidavit?
The Department of Transformation and Development. This is the department under which this institute functions, my lord.
It's a government institute.
My lord, this is a society, my lord, registered society.
ICSSR and the
It
government.
is funded 45% by ICSSR, 45% by the state of Assam, and 10% the institute generates its own earnings, my lord. It's a registered society, and in fact, my lord, there are decisions, there are communications, my lord, which stated that the age of superannuation of state universities is followed. Wherever in a state university, assuming, my lord, age of superannuation is 60 years, then
So
the
what is the terms and condition of service of the petitioner? It is governed by which rules?
There is no.
my lord, the rules has been recently framed, whereby there is a provision made in last 2022, my lord, rules has been approved. Prior to that, there was no rule. The rule has also stated as
No,
notified.
Petitioner could not have been serving so many years. When did he join service in this institution?
Lordship, joined in service
98 as a reader, huh?
as, my lord, on the 31st of October 1998 as reader. And while joining, he was working as in the Institute Center for Himalayan Studies, North Bengal University.
No, please listen to the query.
Lordship,
Don't try to jump.
my lord.
We are concerned with his present
Yes.
service, correct? So you are saying there is no rule governing his
No,
service?
rules has been framed in the year 2022, my lord.
Prior to that,
As per decision of the governing body, my lord. Governing body is the
Memorandum of understanding.
governing body of the GB of the institute, my lord. As per decision resolutions of the governing body, my lord. As per the memorandum of association and rules of the institute. That has been annexed, my lord. All the
So therefore, the government of Assam has nothing to do with his.
the government of Assam, they share 45% all expenditures.
Maybe, but the petitioner services are governed by the decision of the governing body.
Governing body and memorandum of association.
As well as by the government has part of is a governing body. Government is also a member of the. This is all the.
Mr. Chakravarti, we will hear the matter today, but you have to satisfy the courts on this count.
My lord.
Otherwise, the petition will be dismissed.
My lord. My lord.
All emotional arguments will not do.
No, absolutely.
We will go by strictly by law.
Exactly.
You have to show me which is the rule under which this governs.
Yes, ma'am.
If he is not governed by a government of Assam rule, then the question of directing the government will not arise.
Yes.
Will not arise.
Yes.
You have to show where is the parity and why he is a professor, under which rule, what is his terms, and what, according to which rule he is retiring at the age of 60.
My lord.
Memorandum of association. Their own memorandum of association says retirement age is 60 years.
Let him.
Yes.
Why is he retiring at 60, not at 55?
No, my lord. What? Lord.
Please understand the question.
Yes, my lord.
He will retire at the age of 60?
Yes, my lord.
Why 60? It has to be mentioned somewhere.
My lord.
Where is it mentioned?
My lord, it is specific.
Find out. I'll come back.
Was appointed as reader. Lordship, I kindly turn to page 67 of the writ petition. Annexure 2, my lord. In pursuance of the decision of the governing body, in its meeting held on so-and-so, Dr. Bhupen Sharma, lecturer, political science, Center for Himalayan Studies, North Bengal University, is appointed as a reader in this institute in the UGC approach scale of pay. He will be on probation for a period of so-and-so, so-and-so. My lord, on 31st of October 1998, the petitioner was appointed. My lord, the next page.
1 minute, 1 minute.
That's it.
Yes.
If your lordship turns to page 68. My lord, the petition on February 14th, 2007, the petitioner became professor under Career Advancement Scheme. In pursuance of the approval of the 34th meeting of the governing body, the institute held on so-and-so, Dr. Bhupen Sharma is promoted to the grade of professor under Career Advancement Scheme of the institute in the UGC scale of pay plus other admissible allowances from the date when he attained the qualification for promotion under CAS. My lord, he became professor on 14th of February 2007. If your lordship turns to next page 69, my lord. A post of professor fell vacant. The petitioner applied and he was regularly appointed as professor in the same institute, my lord. By page 67. Order dated 15th of March 2012. In pursuance of the resolution of the 46th meeting of the governing body of Amiya Kumar Das Institute of Social Change and Development held on 13th March 2012, agenda item number 4, Dr. Bhupen Sharma is appointed as a professor at the institute with immediate effect in the UGC scale of pay of rupees so-and-so with admissible allowances as per institute's rule. As Dr. Sharma was already a professor under career advancement scheme of the institute, his salary will be protected. He is to join promotion with immediate effect. Initially, my lord, he was promoted to the grade of professor under CAS. Subsequently, a regular post he applied and he was appointed as, my lord, professor, my lord. Well, in the meantime.
So this, just to rewind a little bit.
My lord.
This notification at page 67.
67.
Yes.
My lord.
So this was preceded by an advertisement in the newspaper and things like that, a regular
By
selection.
advertisement, by the governing body. The interview was taken, but normal procedure is that as per the memorandum of association and rules of the institute, my lord, that has been annexed. Governing body has the power to appoint. And appointing authority is the GB. GB conducts interview on the basis of applications received. Thereafter, this was issued, my lord. This appointment was issued.
So this is an autonomous institution, has nothing to do with government. This is where you are probably not understanding.
No, my lord, I got what lordship has pointed. My lord, the issue is, my lord.
See, Mr. Chakravarti, the court would definitely like to give benefit as much as possible.
Yes.
But it has to be a benefit following under the law.
Exactly.
Not merely because somebody desires it.
Yes.
This institution might have been set up by funds from the government.
Yes.
Government may have some even control over it.
Yes.
But that will be completely different from a government institution, which is covered by a set of statute or statutory rules.
Yes, ma'am.
The age of retirement is not enhanced by any other manner, but by amending the rules. Whenever the age of retirement is to be either enhanced, mostly it is enhanced.
Yes.
It is done by amending the provisions of the statute.
Yes.
Because it is the statute or the rules which provides what would be the age of retirement, superannuation, this is provided by the rules. So, if you can show that these rules of the government are directly applicable to the petitioner,
yes,
which it looks difficult because with the governing body taking decisions,
yes,
are these decisions approved by the government?
yes, but governing bodies' decisions are approved by the state government, my lord. They are required to be.
But is this service governed by any set of rules? That's what I'm asking you.
That is why, my lord, rules has been framed. They are prior to 2022. There were rules as such. Rules were framed in the year 2022, given with retrospective effect from the inception of the institute.
Right.
The institute was, my lord, was formed as a joint initiative of the state of Assam as well as the ICSSR.
Right.
ICSSR, lordship knows, my lord, it's an institute under the Ministry of HRD, earlier HRD, now it is Ministry of Education, 100% sponsored by the central government. Therefore, my lord, the state government has deep and pervasive control over the functioning of this institute as well.
That's what I'm saying. That is another thing.
Yes.
This Amiya Kumar Institute or whatever it is called, it's an authority under Article 12.
Yes.
That is a completely different chapter.
Yes.
What I am on is that which is the set of rules which governs the service condition of employees of this institute?
That has been, my lord, annexed.
Where is that rule?
That rules has been annexed, my lord.
Yes.
Page 164, lordship.
Page 164.
It starts, my lord.
Hmm.
It was approved by the GB in the year 2022 only, my lord.
These rules are framed under which provision of law?
My lord, as per the memorandum of association and the rules, the GB has the power to frame rules. And this rules has been approved by the governing body, approved by the state government, my lord.
You want to do some more research or you want the judgment to be delivered today? I think you are not, probably, you are trying your best, but you are not getting into the real legal issue here.
Lordship, may I place one document from record where, my lord, the Ministry of Human Resource Development has clearly specified.
It's not going to help you.
And in fact, my lord,
The
here are
rules are framed by governing body. It still continues to be autonomous institution. As long as you cannot cut the autonomy and tag it with the government, these are policy decisions.
well, rules were approved by the, well, this rule, whatever all the decisions of the governing body has to be approved by the government only, my lord. Only after approval, this decision, my lord, are implemented.
There are many things which are approved. The government's approval is there in everything. Even when you're running a business as a private institution. If the GMC doesn't approve, can you run it?
My lord, here in this
Does
case.
it become a
No,
government
my lord.
business?
No, my lord. But here in this case, government has approved certain things. When GB has taken a decision for enhancing the age of superannuation, government has rejecting that, my lord, since 2014 and finally, my lord, in 2022.
So let us, now in 165, where is the age of superannuation?
Lordship, 177.
177.
The age of superannuation of a faculty and academic staff of Omio Kumar Das Institute in its permanent full-time service is 60 years, / as notified by government from time to time. Retirement is effective from the afternoon so and so. My lord, faculty includes, my lord, professor, assistant professor, and associate professor.
Now, let us test it. Assuming that the court accepts your argument,
My lord.
what is the direction you will be seeking? What is the direction you will be seeking?
Well, already, my lord,
What is the direction you will be seeking from the court?
it should be enhanced to 65, my lord.
It should be enhanced how?
My lord, because it is written as 60 years or as notified.
You are here, you are appearing in this case. As what? Yes, please come. I'm not convinced with your arguments. Unless you come up with something good, difficult.
My lord.
You have to be clear on what you are asking. Unless the rules are amended.
But there is a my case is that, Lordship, kindly bear me for 2 minutes, my lord. Well, faculty includes professor, assistant professor, and associate professor.
That's not the point.
No,
What
but
is rules have to be amended.
No, my lord. Rules are, according to the petitioners, my lord, the rules is clearly or as notified. When notified, government has already notified by way of a cabinet decision that for professors it will be 65 years. Lordship, kindly see, my lord, the age of superannuation of all faculty and as academic staff of Omio Kumar Das Institute of Social Change and Development in its permanent full-time cadre is 60 years / as notified by the government from time to time. My lord, in respect of professor, faculty includes professor, assistant professor, and associate professor. And in respect of professor, government of Assam, by the cabinet decision has already enhanced the age of superannuation to 65 years. That notification, that benefit. Well,
that's what I'm asking.
My
The
lord.
petitioner is not a professor under the government of Assam institution. He is a professor within the meaning of the governing, the rules of that autonomous institution, which may have some control of by the government.
My lord.
But that is very different from a college. A government college will be very different because there is a completely different set of, there could be some parity, some similarity, some analogy which can be drawn. But that will
In
not
fact,
make
the
it the
professor
same.
from a government institute, regular university comes on deputation to this institute. From this institute, people goes to other government
universities,
Hmm.
the qualifications, the parameters which are required to be attained to become a professor under these rules
Hmm.
are also exactly similar as under the university systems, my lord. In fact, my lord, there are several communications wherein it has been specifically stated that it should be 65. And in fact, my lord, there are
Appearing for respondent number 5 here.
Of five, Dipankar, I think, my lord.
Sorry,
Dipankar Nath, senior. ICA, sir.
D Nath is appearing. my lord.
Dipankar Nath, D Nath.
no, he is not, he is appearing, but he is disappearing most of the time.
Oh,
He is appearing or disappearing first.
He's on legs in the other post, my lord, he told me.
Can't help it.
My lord, I
I will
said-
record that there is no response from the
No, no.
institution.
He has filed affidavit, my lord. I talked to the, my lord, director of this institution.
Hmm.
Today, lordship just, my lord, rising today, chair, my
Hmm.
lord. I asked her, is a Indiani doctor.
Hmm.
No, not other name, Shorty something. She told me, I asked her whether your institution is a education institution. No. Answer is no. Is a research institution. Whether it has been governed by the any statutory rules of the state government of higher education. No. She has, my lord, stated me. There's a research center already research for the purpose for research. And lordship kindly for a moment, my lord, everybody replied they have filed it. They've annexed, my lord, 24 institutions like that. Amiyo Kumar Das institution like 24 in India. In all the India, in 24 institutions out of that, 888. One institution has 60, 8 institution has 60 years retirement, 8 institution 65 years, 8 institution 62 years. Different. It is depend upon the state government and this institution. That's why in this institution, government policy is the retirement age would be 60 years.
Where is the policy?
But policy, that is, my lord, that is the policy, our my lord. With this cabinet memorandum raised the retirement age of
But
the.
if professors in the government colleges and universities have a retirement age of 65 years,
Yes.
why should this also not be
No,
65?
it is not a educational institution like other educational institution. This is a only research institution. It is autonomous body. Their service condition, condition is, my lord, defined and controlled by their own office, memorandum of association. That is page 77. I have seen all these things. And now the government has raised the age of superannuation of professors, all the professors, 60 to 65, including medical hospital education. That is the cabinet decision of the government. And now government has not has not decided to raise the age of this autonomous institution of professor. Mere nomenclature of professors. It does not mean it's a professor of the education institution. Indiani doctor, Lordship Kalisi pays.
What is Mr. Nath? Please call him. Please call him. Otherwise, I'll have to direct personal appearance of the director. Call him.
Indiani, Indiani doctor. She was a director. And she appointed him as a professor. At that moment, she was a director. She retired at the age of, and we have mentioned in our affidavit, additional affidavit, she retired at the age of 60 years.
And my lord,
Now
the
he is
vacant-
claiming now I want to be 65 years.
My lord, may I intervene for a moment?
In a whole application, this writ petition is voluminous only because of all our resolutions. All are resolution of their own. They are taking some resolution from time to time. Now we have filed an affidavit, additional affidavit, we have said this education institution because it is not an education because there is no calendar, there is no holiday like
That's not
other.
the point. Education, research is what? It's nothing to do with education.
Education
All
is-
research institutions are educational institutions.
In research school,
That we can clarify in 5 minutes. That's a erroneous supposition.
widely,
But the problem here is that the service conditions continue to be governed by their own set of rules.
yes.
So they will have to change the rules.
The rule is not says, it has to be approved by the government also.
First, let them change it.
That is the government has not said
May I-
that one
may I
taken up.
intervene for a moment?
Well, 60, 77, Lordship, kindly see, I am.
Only for 5
Lordship,
minutes.
page
There are
77.
24
Page 77, Erasa 6. They have already details developed so and so, place or to fixation of original pay scale, the result recommendation. The faculty members who are evaluating UC scales of pay, Dr. So and so complete the process of completion. And the result of the recommendation 6 pay commission notification, service condition would continue to be governed by the institute's rules and regulation, except in case of ambiguities or institute's rules not being clear. The service condition as prescribed in the
AMS RD, the notification of autonomous activity. The service condition would continue to be governed by the institution or career advance scheme. Their own responsibility. It
That's
is
what
not
I've been
common.
saying.
That
That's
is
what-
rightly not pointed out because there is, this is not a code, it's a university is there, Guwahati University Act is there, own state act. And higher education act is there, but commercialization of college rules like the colleges govern. So in this case, totally a research institute, the research scholars are come.
Even if it is a research institute, what is the problem? Problem is not that. Problem is which probably, I don't know whether he has understood. There is a roadblock here. These orders will not be implemented unless these are in accordance with law. At the moment, what you have argued doesn't make out a case for your client. Why aren't you reviewing the regulations with after the enhancement of the age of professors in other institutions? What is the problem in doing so?
These are
This is an autonomous institution.
these are institutes funded by the ICSSR and the state government. But the ICSSR has these type of institutes, 24 institutes throughout the country. And Lordship in the affidavit has seen that the retirement age of all the 24 institutes are different. But in fact, they have said, we have filed the affidavit and it is the stand of the authorities that it is the state government, ultimately they will decide whatever the retirement age for these employees in their respective state. And here in our affidavit, we have in detail said that the state government has a proposal sent to them, they have rejected and they said that it will be 60 years. That cabinet memorandum has Lordship has seen.
Where is that? Where is that?
My lord, that or impute order.
In the affidavit filed with the state, my lord, it is there. In our affidavit also, my lord, the affidavit kindly take up. The affidavit filed with the respondent number 5, 6, and 7, my lord.
No, but what is the ground on which it is rejected? Why it should not be treated? They should not be treated at par with other professors in other academic institutions.
Those are educational institutions. These are not educational institutions. These are the research institute and they are not performing the regular academic the exercise. In the affidavit, filed by the respondent number 5, 6, and 7,
yes.
The on behalf of the director who have filed. Serial page number, I'm just referring to the page number 299,
299.
Page number 299 and Annexure 13.
Is there another file?
Yes, there is a separate affidavit filed.
Yes.
For a moment, kindly come to 296, Lord, Annexure 11.
295.
Annexure 296, Annexure 11.
Yes, please.
Lordship. This is a communication by the Secretary to the Government of Assam Planning and Development Department to the Director. Kindly come to serial number 2. The matter relating to retirement age of faculty members and both other staff of the institute has been considered in detail. After careful consideration of retirement age of the employees of Government of Assam, other institutes established by the Government of Assam, UGC circular, Supreme Court verdict, etc. on the subject, it is felt that the retirement of both faculty member and other staff of OKD Institute, Guwahati, should remain at 60 years of age. Then kindly see page 298, Annexure 12.
Yes.
Subject endorsement of Higher Education Department. They said that with reference to the letter on the subject cited above, I am directed to forward here with a copy of the endorsement of Higher Education Department regarding the retirement age of the faculty and other staff of Omya Kumar Das Institute of Social Change and Development for your needful action. The next page, Lordship will find the endorsement. This is the endorsement of the Higher Education Department. They said, refer endorsement number so-and-so of Transformation and Development Department for views of Higher Education Department on whether or not Omya Kumar Das Institute of Social Science is an educational institution As per this decision of the cabinet on 19/2/2012, the age of retirement of all professor of educational institutions, including medical colleges, was raised to 65 years. It is observed that Omyokoma Das Institute is the only institute in the Northeast which has the mandate for advanced studies and research in the areas of social sciences, and therefore needs to be nurtured appropriately. Advanced level teaching, training, and research are its mandates, among others. It teaches courses of prerequisites for PhD research over one year to semester as per UGC regulation, but the institution itself offers only certificate course. However, whether or not Omyokoma Das Institute qualifies as an educational institution should have ideally been indicated in its initial resolution or memorandum of association when the institute was established. That we have already annexed in the here. I'll take your lordship to that. As per the aims and objective of the memorandum of association of Omyokoma Das Institute, it appears that the institute is specially established for research and training education. Education is not mentioned. The institute has also entered into MOU with Dibrugarh University for academic collaboration. In the MOU, the Omyokoma Das Institute is described an autonomous research institute and recognized as affiliated research center of the university. There are other affiliating research institutes of DST and under the Government of India research organization like ICMR, CISR, etc. in the state, which are also recognized by universities as research centers for conducting research programs. However, they are not considered as educational institutions as they are not degree, diploma awarding institutes. Retirement age for all in such research center is 60. For an institute to be recognized as an educational institution, administrative recognition affiliation is required from the appropriate authorities such as the state, central government, university, UGC, AICTE, or any other such statutory bodies. In view of the above, the administrative department concerned may perhaps take final call on whether or not Omyokoma Das Institute is to be considered an educational institution for increasing the retirement age of its professors up to 65 years within the ambit of the aforesaid cabinet decision. Then the final decision they have said, the transformation development
Where is the
department.
decision? Where is the decision?
That cabinet memorandum the government has taken. They have informed that in reference to the letter on the subject cited
Just a
above.
minute, cabinet memorandum is in page 296.
No, 296 is the communication of the department. It's of 2014. Cabinet memorandum, the affidavit of the government has filed.
So cabinet memorandum, lordship will find at page, not running page 441, my lord.
No, page number.
So it is under challenge.
No.
Which one, my lord?
Cabinet memo decision,
No.
No, my cabinet memorandum which is in our favor, my lord, basically.
440.
440, the forwarding, my lord, and 441, the last page of the affidavit. By additional affidavit. This is the extract of final.
You're not understanding that cabinet memorandum is for professors.
Yes.
The issue the government has raised here is that this institution is not an educational institution.
My lord.
The decision of the cabinet will be applicable only to educational institutions, including medical college.
Yes.
That they make it very clear.
Yes.
Yes.
So if you can show that it is an educational institution, then you are covered under this.
Yes.
If it is not an educational institution, then their argument that this decision cannot be made applicable will have to stand.
Yes, my lord.
If this court cannot add letters, words,
Yes, my lord.
expressions to this.
My lord, this cabinet.
Just a minute, just a minute.
My lord.
Don't be in a hurry.
My lord, sorry.
Hurry makes worry. Please don't. There will be many questions which you may not be able to answer.
My lord.
Please listen to what is happening and carefully come up with your response. Now, Mr. Nath, what has happened after this secretary of the Higher Education Department puts up this note and says that let the government take a final call.
Page 300, my lord.
Page
Annexure
300.
14, my lord.
Yes.
I'm directed to, with reference to the letter on the subject cited above, I'm directed to inform you that the Government in Transformation and Development Department regrets its inability to agree the proposal for raising the age of retirement of professor of the Omyo Kumar Das Institute of Social Change and Development. So they, a
No,
proposal was-
retirement age was not the issue. Issue was whether it is an educational institution or not. On what ground it is disagreed? Where is the finding?
But in fact, the view has been, the 2014 letter I have referred of the department, planning and development. Earlier it was planning and development, now it is transformation. That already, kindly see, 296, they have already said that the
No, no,
retirement.
why is it not treated as an educational institution? That's what we want to know.
In fact, 299 page, it is very clear, the second last para. Second last para,
Yes.
there are other affiliating research institutes of DST under the Government of India research organization like ICMR, CSIR, etc. in the state, which are also recognized by universities as research centers for conducting research programs like the Omyo Kumar Das Institute. However, they are not considered as educational institutes as they are not degree diploma earning institutes. Retirement age of all such research center is 60. But there are.
No, that's right, Mr. Nath. I'm asking, we are trying to figure out what really is the issue. That's why these queries are important.
Logic.
The petitioner is urging a right on the principle of parity.
Correct.
He is saying that others are also professor. I am also professor. You are giving him 65 years. You are not giving me 60 years. The road or the route to that relief may be different. But first of all, let us understand whether he can successfully urge the principle of parity at all or not.
Logic.
So his parity argument has been negated or sought to be negated by saying that this is not an educational institution.
That is number
Correct.
one. That is number one.
Yes.
That is number one.
Number one. And what is number two?
Number two, in the here or itself it is mentioned, the last 4 paragraph, in the memorandum of association of the institute, it says that it is established for a specific purpose, not for, it's not an educational institute. And
so what is the criteria of an educational institution? How do you recognize an educational institute?
The institutes which provides for the degrees, they have classroom studies, they are all facilities are there.
This institution is not providing any degree or diploma to anyone.
No. And the memorandum of association of this institute, it provides that the age will be 60 years. It is there. And they are autonomous bodies, ultimately
that is understood. That these technical bars are there. But substantively, the court wanted to understand, because if it is really a case of discrimination, then we'll step in.
True.
There has to be intelligible differential, etc. And which are, the court will not step in unless it finds that it is a case of discrimination.
True.
So that's why at the beginning only I told Mr. Chakravarti, you have to, in fact, the other Chakravarti is also there.
But
you want to add something?
But in fact,
just wait for a minute.
In fact, that is what I have indicated, that the institutes, 24 institutes in different states have different retirement age. It is basically
in those institutions where the retirement age is 65 years,
yes,
those are educational institutions.
No, but the state government on their own, they have taken a decision that let us increase it. They have done that. So the discrimination point petitioner has sought to be urged on the ground of parity, that is not applicable here. Because some institutes, logic will find that age is 62 years. The point they are urging that the UGC notification provides it is 65 years. So all universities, they have done 65 years. So it should be 65. If that is the point, then in respect of the other institutes also, it would have been 65 years, not 60 years or 62 years.
The case of the petitioner is that it should be as per the respective state universities. What is the case is that there are 24 research institutes which are, my lord, out of which 4 institutes are 100% funded by ICSSR. Their age of superannuation is 65 years.
And in respect of other, my lord, the age of superannuation of the respective state university is followed. The case of the petitioner is that in this case also, the age of superannuation of the state universities should be followed. If it is in state universities, it is 60, it will be 60. If it is 65, it will be 65. Lordship, kindly come to my lord. I'll show a case a document, my lord. It is on record. My lord, page 455 of the affidavit, my lord. Of the affidavit in reply.
I'll take your lordship to the object of the institute.
Can you please take your seat? If the court is interested, you make your submission.
Lordship.
What is the hurry? Don't interject in
Lordship.
between. Yes.
But the difference is apparent here, my lord. Kindly come to page
No, but
221.
just a minute. Even if it is a research institution, even then, now that there is a better life expectancy everywhere, people are fit to work. And this decision is of 2014 at page 296.
296.
Why can't the government be asked to review this?
But
And
the final view they have taken in the year 2020, and they have communicated on 9th of August 2022.
Where
Page
is it?
Page 300.
Page 300.
Page 300 is of 2022.
Where is this proposal? Agree to the proposal means who has sent the proposal?
The proposal has been sent by the institute.
Where is that proposal?
But there are various representations, governing body resolutions, all we have, my lordship will turn to page one document, my lord, I'll place.
Mr. Chakraborty, you have to take your seat now. I will ask you when the time comes. One more move and I will have this matter by another court, not by me. Because I am trying to minutely find out what is happening.
Sorry.
If you disturb, then it goes to another court. Huh? This is last chance. These matters are very, very sensitive. I don't want to leave anything to chance. If you disturb again, I'll refuse to accept this, hear this matter. Yes.
But this is in respect to the.
Where is the proposal which was turned down by 9th August 2022?
The subject is proposal for raising age, my lord. That is that I am referring to.
But do you have the proposal? On
the copy we have not annexed here, my lord. Copy to my next one.
But this does not give any reason why it is not agreed upon.
So finally, they have taken the view of the higher education department. In fact, whether this can be treated as an educational institute or not, that view has been taken.
No, assuming that it is not an educational institution. Even then, every walk of life, now the life expectancy being better, these are research scholars. It's not about only one. There are other faculty members also. So, therefore, a reasoned decision is required to be taken.
Look, while placing it before the
Both
cabinet,
the decisions don't give any reason except that it is a research institution. So, no. But
that decision
research
of the,
institution is.
that what I find out, they are referring to the UGC decision that the enhancement of age is applicable for the universities, educational
But the
institutions.
UGC doesn't say it will not be applicable to others.
In fact,
The other institutions, their employees can never claim, or their institutions, the employees and faculties can never have age. There is no such resolution.
in fact, the power has been given to the authorities. They have taken a decision.
No, but what is the reason for this?
The reason is this, as I find from these papers, that it is not an educational institute. That is why it is not extended to them. That is what reason I could find. If
there are many institutions which are not educational. There also the age of retirement is higher. 65 years or 62 years is there in many other institutions. In the state of Assam, the government servants retire at 60, is it not? And 65 years is for professors.
Professor.
Any other category of age of retirement?
No, to my knowledge, no.
It's not there.
No. 65 is for educational institutions, including medical colleges. In respect of educational institutions, including medical colleges. In fact, the Ayurvedic doctors, they also claim that same benefit that has been negative. That has not been given.
Any appeal preferred against that judgment?
But to my knowledge, but some, I don't know. There may be, Malad. I'm not sure. Malad.
So 65 is as per UGC decision for
Gotcha.
teaching faculty,
Yes, Malad.
which are who are connected with an educational institution.
Logic.
Position.
Not for the employees.
No. And my lord,
And who is appearing for ICCS? Here.
Yes.
They are standing also same.
Yes, Malad. We have filed the affidavit, Malad. In the affidavit, we have said that it is as per the memorandum of association, and it is for the state government, concerned state government. They will take the decision.
so I start in the Google, my lord. What is research center? Like a research center is a formally structured unit within the university, other than a department or a school. Other than a department or a school. Established with the purpose of advancing scholarly activity primarily through collaborative research training, research dispensation, and creative endeavor. These are the only purpose. The education institution is a regular education imparted to the students, arts, science, and commerce like that. Regular student admission is there, regularly admission is there, calendar is there for holiday, and their examination is there like that. But in the research center, they are only research center. Now the other Dibrugarh University, they have collaborated with the Dibrugarh University. Dibrugarh University has a understanding in between them. They have annex here. So they are send the research students. So those who are research students, they are doing PhD, send for guidance of this. They are taking it, they are supervising it. After training, they are sent back to the university. Accordingly, a PhD degree given by them. It is the center. And another definition, may I read it? I wrote it. A research center is a formally structured unit within the university, other than a department or a school, established with the purpose of advancing the so research center. This so I have read it. They provide unique inquiry basis learning opportunity to students and to the activity engaged in the relevant academic forums and community outreach. Center typically involve activities beyond the scope of single disciplines and promoting interdisciplinary work. So in education preparation like higher education, these established colleges are there. In college there is no professor, only associate up to associate professor. Only professors is in the university. In provincialized colleges, they are up to the only associate professor, they will be retired. And in university there is a rank of professor. And those professors are entitled for retirement benefit on up to the age of 65.
Only professors.
Only professors.
Or associate professor?
No, they are not.
Only the professor.
Yes.
And what is the gap between reader and professor?
After retirement, they will promote it to the professor. Gap is there.
After reader, the next post is professor.
Next post is professor. Then he will retire as a professor. And there is no other nomenclature. VC is there. So all professors in universities and colleges, government colleges are different thing in provincial colleges. So these are the facts of why we are not accepting their proposal.
So associate professor, assistant professor, in their case?
No, they are not getting.
It is same, 62 years.
60 years.
60 years.
60 years.
Only those who become professors. So petitioner is a professor, but is he drawing the same pay scale as professor in?
Pay scale maybe they are, they have adapted, not adopted. We have filed our additional affidavit, lordship will find all these things. We are our additional affidavit, lordship, my candidate. Additional affidavit, my lord.
Yes.
Our additional affidavit page is my defines, my lord. Running page.
No, but you still mention what is the page?
Page 220, our page, my lord.
Page?
220.
starting from 200. Our affidavit, my lord, the page is not continuously given. 218.
Running page should be 423.
423, no?
Running page should be
Our affidavit, no? Yes, we have mentioned it, my lord. Paragraph,
Yes.
paragraph 6, lordship, kindly see it for a moment. The report begs to state that OKD has its own service regulation for the faculty, professor, associate professor, and assistant professor, and administrative staff. Since it is a research institute and not a teaching institute like university, it is a non-vacation organization. Non-vacation organization means there is no vacation, madam. And therefore, service regulation with respect to leave, except a offer from UGC, unlike universities which are geared to impart theoretical knowledge through classroom teaching and contribute towards theoretical research. OKD under ICSSR was set up to promote policy research to support government, and therefore scholars from different institutions are recruited. And recruitment is not merely from universities. Different institution, but this is like the petitioner. He participated in the open advertisement for the post of professors. And Indrani Dotto, who retired at the age of 60, she was director in this institution. She came from the Guwahati University on leave. Thereafter, she resigned in the Guwahati University post, and she continued it up to the 2017.
Is it a pensionable service?
I think I don't know, Malad, there is a pensionable or not.
Is it pensionable?
I have to take.
I don't think, Malad, is a
I have to
pensionable.
take that instruction.
This director.
No.
Director, not
this-
pensionable. So
The petitioner will receive pension.
no.
But UGC scale has been adopted by them. It's a.
It's their own decision.
No, I want to know because professors are entitled to pension.
Yes, university professor and college associate professor, they are entitled to pension.
Pension. But will is the petitioner also
I'll
entitled?
take that instruction right now.
Ask.
Therefore, although qualification and pay have been adapted, we have said ADAP, and not adopted from the UGC by the institutes, service condition including leave, promotion, etc. vary from institute to institute as per their service regulation. The promotion of faculty are as per guidelines of the ICSSR and not UGC. We have stated here, Malot, not UGC, as per ICSSR. And these 24 institutions are, some are centrally funded. And those centrally funded, we have annexed a letter, annexer 3, page 230 our Lordship kindly see, 23rd March 2007, we have annexed a letter to the Secretary Investigations Commission. So enhancement in the age of superannuation 62 to 65 years of teaching position in centrally funded institution in higher and technical education. May I read it? I am directed to say that at the time of revision of pay scales of teachers in the universities or colleges following revision pay scale, so and so was it, and retirement age was 62 years. I am skipping out, my lord. Paragraph 2. The matter has been reviewed by the central government in the light of the existing shortage in teaching positions in the centrally funded institutions in the higher and technical education under this ministry. And in the context of government's decision to expand the capacity of such institutions for increasing access to higher education and for implementing the policy of reservation for the weaker section without affecting the number of seats of the unreserved category available through the general merit. Accordingly, it has been decided that the age of superannuation of all the person who were holding teaching position on regular employment against sanctioned post on 15 March 2007 in any of the centrally funded higher and higher technical education under this ministry shall be increased from 62 to 65. Those who are centrally sponsored by the central government.
But there is no pension.
And no pension. And next, my lordship, kindly, person holding such regular teaching position who have superannuated prior to 15 March 2007 on attained the age of 62 years but have not attained the age of 65 years may be re-employed. And next, my lord, all person holding teaching position against the sanctioned post may also be considered for re-employment beyond 65 years. Next, paragraph 3. It is further clarified that enhancement of retirement age as mentioned above and the provision for re-employment will apply only to person in teaching positions, again post-sanctioned to the centrally funded higher and technical education institution coming under the purview of this ministry in order to overcome the shortage of teachers. These are the letters from the Malot Government of India. We have annexed here, Malot. So accordingly, this letter also the petition is not entitled. So we have made it our affidavit ballot in paragraph right from 6 onward up to 9 ballot. We have stated here ballot. Without state government cannot approve. Yes. The governing body of paragraph 8 ballot, Omyo Kumar Institute Social so age 65 days retirement age is so and so, letter so and so. The governing body has representatives from ICS and government of Assam. And they are also finding 45% each. Institution. A governing body cannot take decision without the concurrence of government of Assam and ICS. They are taking resolution. So many resolutions are annexed here, Malot. They are taking only resolution that this should be there, this should be there, this should be there. That not implemented until and unless concurred and approved by the ICS and government of Assam. So till government of Assam has not concurred and has given so what is the grant their adopted to adopt 65 years. The government has not come, has not final decision to raise their retirement ages up to 65. The decision of governing body to continue superannuation age of 60 years in the service rules were taken, keeping the view of the decision conveyed by the government of Assam. The memorandum of association and the service regulation by institute clearly mentioned this is a research institute. Their own memorandum say this is a research
Where is
institute.
the article of association memorandum? Is it part of the record?
Part of the page 231, is the affidavit of
Page?
page 231 of affidavit of response of 5.
Acha, we'll ask him when he says, when he submits.
Yes.
So that's your stand.
That is my statement. And there is no regular classroom like that, and then imparting no education, arts, science, commerce like that. And there is no admission of the student also. There is no vacation also, summer vacation, winter vacation.
All right, you have said that.
That is not under the education institution.
It's a society.
Society is that.
231, the of memorandum of association is we have annexed, no? And the stand of the respondent number 4, the ICSSR in their affidavit we have stated, particularly I'll take your lordship to 2 paragraphs. Para 6 at 308 and paragraph 8.
That is the affidavit by ICCS.
ICSSR. Page number relevant is 308. It starts at page number 301. But paragraph 4 we have said why this has been done. Referring to para 6, that in order to carry out its functions and objectives, ICSSR has recognized 24 research institutes in the country, which includes Omyo Kumar Das Institute of Social Science and Development, Guwahati. Omyo Kumar Das Institute was brought under the ICSSR in Grant in Aid scheme in the year 1989-90, and since then has been receiving the recurring and non-recurring grants from ICSSR. The Omyo Kumar Das Institute Guwahati receives 45% grants in aid each from state government of Assam and Indian Council of Social Science Research, and OKD has to generate remaining 10% from its own source. Omyo Kumar Das is involved in various research activities in the field of social sciences. The ICSSR grants in aid rules approved by the government of India by so and so clearly lay down the following condition of assistance we have stated below. Then we have said.
Yes.
Paragraph 7, we have said that the ICSSR sanctioned 7 academic and 12 administrative posts in the Omyo Kumar Das Institute, Guwahati. And as per the service record provided by Omyo Kumar Das Institute, the petitioner was appointed as reader with effect from 9/11/1998 in UGC approved pay scale. Thereafter, the petitioner was promoted in the grade of professor under the career advancement scheme of the institute in the UGC by the institute's notification dated 14/2/2007. Details about the petitioner in the service records are in the already before the honorable court, and in our affidavit also we have stated. Subsequently, an advertisement was there. He responded to that and he was appointed. Then paragraph 8 we have said that the government of Assam in its notification dated 26/9/2012 have clearly stated that age of retirement of professor of all educational institutions, including medical colleges, is raised to 65 years. That we have annexed at page number 372. That is issued by the Education Department. The government of Assam, however, has not recognized the Omyo Kumar Das as an educational institutions. The Omeo Kumar Das is recognized as research institute by the government of Assam. The notification dated 26/9/2012 is therefore not applicable to the faculty of Omeo Kumar Das Institute. Even the memorandum of association of the institute does not define it to be an educational institute. It is submitted that clause 32(1) of the service regulations 2022 of the Omeo Kumar Das Institute of Social Science and Development states as under: the age of superannuation of all the faculty and the academic staff of the Omeo Kumar Das Institute in its permanent full-time service is 60 years, as notified by the government from time to time. Retirement is effective from the afternoon of the last day of the month in which age of superannuation is attained. So this is the rule of the institute. The cabinet decision of the government of Assam dated 19/9/2012 and notification issued pursuant to thereof on 26/9/2012 is not applicable to the Omeo Kumar Das Institute for the reasons stated above.
All right.
Page 372, the decision which they are relying on, that this has to be applicable. This was issued by the Higher Education Department. That is why the Administrative Department of the Omeo Kumar Das, the Transformation and Development Department, they have sought the views of the Higher Education Department. That they kindly see page 372. They said that I am directed to convey government's decision taken in the cabinet's meeting held on 19/9/2012 as stated below for taking necessary action from your end. This was to the vice chancellors of all the universities. It was decided to raise the age of retirement of all professors of educational institutions, including medical colleges, to 65 years. So this was a decision taken by the cabinet, and the higher education has intimated to all the universities. So this was they are relying for their benefit. That is why the clarification has been taken by the department from the higher education department, and that I have.
So is this under challenge 2012-2014? Is it under challenge?
No.
Which one, Lordship?
No, this is not on
20th of December 2014, by means of which the proposal was
Yes,
rejected.
both are under challenge. Madam.
These are under challenge.
Yes, sir. Including the last rejection at page 205.
Yes. Anything else, Mr. Mark? Anything else?
But so the stand of the respondent number 4 ICSSR and the director is very clear, that as this is a registered society, registered under the Societies Registration Act. It has its own rules and regulations, and the memorandum of association is there. As per that, it provides that the age of retirement is 60 years, and in fact, from time to time, the proposals where they have raised it before the government has not considered.
Yes.
Lordship, wanted to know about the proposals submitted before the government.
No.
That proposal.
For your benefit,
My lord.
Mr. Chakravarti, other Chakravarti is also there. The case hinges on this point.
Yes.
The age of retirement of employees in every institution is governed by the set of rules or regulations framed by that institution.
Yes.
So in the government of Assam, the age of retirement is 60 years.
60 years.
Now, the institution where your client serves, that also has a regulation which makes it 60 years. And this is in consonance with the retirement policy of the government of Assam. As the case is. Now, the problem arose when in 2012, the government of Assam the cabinet decides to enhance the age of superannuation of all professors in educational institutions, including medical colleges. Now, that decision is obviously in consonance with the earlier Government of India circular, which was issued to enhance the age of retirement from 62 years to 65 years to achieve a purpose. That purpose was there was a shortfall of teachers. So therefore, if large number of teachers are allowed to go on retirement in the rank of professor, this is going to adversely affect the educational institutions. So they took a policy decision. These are always policy decisions. And that policy decision was notified. It was applicable to all central government universities, etc. So later on, the government of Assam, for whatever reason, maybe the similar problem was faced here. They also agreed, the cabinet agreed to accept it for the professors in Assam, and accordingly it was done. Now, your case is, since the post you are holding is also nomenclatured as a professor under the regulations, and since the pay scale is the same, therefore, regardless of anything else, you also have to be treated as a professor in any other university, and therefore, since the professors in universities and educational institutions have a retirement age of 65 years, you also have to have a retirement age of 65 years. That proposal was sent to the state government, and they declined it more than twice. Said that no, it is not permissible. The reason they have given is that it is not an educational institution. And perhaps that is correct. It's a research institution.
Yes.
So the logic which went behind the enhancement of the age and subsequent acceptance of the same by the state cabinet, according to the government, has nothing to do with your institution, because there was no shortfall of teachers in this case. You are like any other government employee. You will retire, somebody else will come, and this is a research work which will go on. So the concept of applying enhancement of age for professors in educational institution, according to the government, is clearly missing in case of OKD.
Yes.
And so they have turned it down. Therefore, the court has to see whether this decision is arbitrary and discriminatory. Your argument is only that your nomenclature is professor.
No, my lord, apart from that, my lord, I would like to place one more aspect.
No, you will place it, you will place it. You will place it today itself.
My lord.
But what the court will also have to consider is that these are policy decisions. If it is a conscious policy decision and there are intelligible differentia, that's the end of the matter. Know it very clearly.
Yes.
The courts cannot step beyond that.
Yes.
Correct?
Yes.
Whether this ought to have been the case, that should have been the way it is, this would have been better, these are not the domain of the court.
Yes.
The court will see that everybody else in the system, every other employee is getting 65 years, only this man has been left out. Oh yes, that's discriminatory. But whether another class of institutions should be brought in, policy matters. Number two, when the age of superannuation of professors were increased from 62 to 65, at that stage also your client did not have a retirement age of 62 years.
My lord, two professors of the same institute retired at the age of 62 years. I have specifically stated, following that principle. In the affidavit, that no reply has been made. Lordship, can you kindly see paragraph.
No, they have retired at 62, but the retirement age is 60.
My lord, two professors, what I am saying, my lord, two professors of the institute, they were allowed to work in the institute beyond 60 years.
Illegally allowed.
No, but
the law says it's 60 years.
As per the law prevailing at that point of time, my lord.
Correct.
Yes.
So that is no longer there. Today you have a regulation of 2022.
2022.
And that says it's 60 years.
60 or as less as notified by state government. Case of the petitioner.
Correct.
Yes. My lord, what petitioner is saying, my lord, as per documents, my lord, even the central government, which is, my lord has stated, it should be as per state university. This is not the case of the petitioner, that it should be only as per UGC. Whatever is in the state university.
The key word is educational institution.
Yes, my lord.
If you show that this is an educational institution, you will have a case.
No, my case is that only on the ground that it is an educational institution and research institution, by sub-classifying a professor, for such kind of classification is nowhere to be found in the UGC regulations or any other.
Matters of policy, we can't get into it.
But in the form of affidavit only, they have come up with this, my lord, classification of a professor. Well, the qualification.
In 2014, they have mentioned. 2014 notification, they have mentioned that this is an educational, not an educational institution.
My lord, thing is that 2014, they have mentioned, now that decision is also under challenge in this writ petition. Honorable Lordship, kindly, I wanted to place
So now
one.
you want a direction that the regulations should be set aside.
No, but I don't want regulation to be set aside. My case is that regulation has specifically why that slash as notified by state government has been introduced. I'm trying to.
Yes, that's right. So if you can show that it is a educational institution, we'll allow your prayer.
But it
We'll
is
allow
not an educational institution,
Yes.
madam. It is not an educational. But thing is
And
that.
then how, as notified, government of Assam has notified that all professors of educational institution, including medical colleges, will have a retirement age of 65 years. So if you can show that this is an education institution, you have a case.
What I am saying, my lord, there are 24 research institutes similar to that of the Omyo Kumar Das Institute.
That will not help you.
Lordship, kindly bear me for 2 minutes, madam. And out of that 24 institutes, 4 are 100% funded by ICSSR. There are documents, my lord. I can place it here for lordship. Where the age of superannuation of professor is 65 years. And in respect of other institutes, which are jointly funded by the ICSSR and the respective state government, like Omyo Kumar Das Institute, the age of superannuation of the state universities are followed. Therefore, my lordship, that document I would like to place, my lord.
So we'll continue after lunch.
My
What
lord.
do you have to say, Mr. Chakraborty? Or do you want some more time to research on these points, or you want it to be over today itself?
My lord, may I pray the matter will take up on Tuesday, my lord, because I have to leave, my lord, today in the afternoon.
Tuesday fixed part matter. So
On 30, this take no.
30th as a fixed part matter. But
My lord,
Mr. Chakraborty is whatever you argue, that's up to
My
you.
lord.
But please understand what is the real issue.
Yes, absolutely.
If you don't understand it, you will be addressing the wrong issue.
Yes.
I am again repeating, the courts are not here to question the policies of the government.
Yes, madam.
The court will only see if it is a case of violation of Article 14 and 16. As a class, if they have only accepted the enhancement of age for professors in educational institutions, there are reasons available for doing so. And he is not a professor in an educational institution. Very, very difficult.
Madam.
Practically,
Madam.
you have to be very
Yes,
clear
madam.
about it.
Yes.
Make out a case, show that it is an educational institution.
Yes.
Now, the courts will not go into this exercise
Definitely.
in declaring that this ought to have been treated as a right. That argument, don't make it,
Yes.
because I will not even deal with it. This is not our job to declare. The question is, it is not an education institution. You have to show it from the article of association that this is an education institution. Matter ends there. Then we'll question them.
Yes.
Despite this, why they are holding. But if it is not an educational institution, then for whatever good, bad reason, he has to retire.
Yes, madam.
The court cannot, what will the court do about it?
Definitely.
The court cannot direct them to allow him to continue contrary to the regulation.
Yes.
Government policy, again, does not apply to non-educational institution. For other government policy is 60 years. So that would also be in consonance with the regulation. And this matter appears to have been substantively gone into. So every case can be won.
Yes.
It is up to you now what kind of research you come up. Don't repeat those arguments you have made today. These arguments are leading to dismissal of the writ petition. Don't even repeat anything you have argued today. These are of no use. I will just keep quiet and listen to you because I have to hear you. But these arguments.
Lordship, as per my last order dated, my lord, 2023, my lord, I have received, yesterday I have received instruction, my lord. There is no any, my lord, arrear salary to be paid, my lord, to the petitioner. And he is not claiming for pension, my lord, on last occasion.
My lord, matter pertains to my lord, non-payment of arrear pension retirement benefit, my lord, led by the father of the petitioner, my lord. The father of the petitioner, my lord, serving as a masteral worker, my lord. His post was regularized in the year 2005, my lord. And thereafter, my lord, in the year 2008, he retired, my lord. And subsequently, in the year 2022, my lord, he died, my lord. And my lord, from retirement to till his death, my lord, that pension portion, my lord, portion has not been released, my lord.
Pension, he is entitled to pension.
Area pension, my lord, area pensionary benefit, my lord. Because, my lord, the father of the petitioner is having more than 20 years of service, my lord.
Then you have to file affidavit.
My lord, I had filed my affidavit, my lord, on my lord, 10th of July, 2023, my lord. So, my lord, at that time, my lord, when the petitioner father retired, there was no policy for pension, my lord. And my lord, he have that annex, my lord, annexer 10, my lord.
No,
that-
no, when retired, no, when he was regularized in
Regu-
service.
Yes,
Regularized.
regularized 2005, my lord. And my lord, he was regularized, my lord, and as per Sanjita Roy, my lord, continuous 20 years of service, my lord. They were eligible for pension. But my lord, petitioner father, my lord, never approached before this honorable court, my lord, in the last 13 years, my lord. And my lord, petitioner, he is my lord 52 years, my lord.
No, my lord, my lord, father died in the year 2022, my lord.
Yes,
This
my
has
lord.
been listed for orders. What order?
My lord,
Why it has come up for orders today?
admission.
Oh, so this is for admission.
Kindly see, my lord, page 19, regulation order, my lord. The father of the
Page?
page 19, my lord.
So when was the father engaged?
Engaged, my lord, in the year 1972, my lord.
My lord, there was no record, my lord.
No, one by one, not
Yes,
like
my lord,
this.
my lord.
This is not a drawing room
Yes, ma'am.
proceed. This is a court proceeding.
Yes, my lord.
Take your seat, let him finish.
My lord.
Yes, when was the petitioner's father engaged?
Engaged in the year, my lord, 1972, my lord.
Any document to
My
show
lord,
that?
kindly see, my lord, one document was reflected by the page, my lord, 36. It is the, my lord, letter, my lord, where is the, my lord, respondent stated, my lord, the petitioner serving since 1973, my lord. 72, my lord. Being a master rule, my lord, the respondent has maintained, my lord, the vouchers, my lord. I have annexed, my lord, annexed 2A. In 2A, my lord, it is, my lord, reflected, my lord, June 1983.
All right, now what has happened? When did he retire?
Retired, my lord, 28 to 2008. Kindly see, my lord, page 38. Page 30, that is the retirement notice, my lord.
All right.
And died, my lord, in kindly see page 40, my lord. He died on 23 to 2022, my lord. And during his lifetime, the respondent has not, my lord, paid any, my lord, retirement benefit, my lord, including pension.
He died on 14/3.
My lord, 23 to 2022, page 40, my lord. 14/3, 2005, my lord, the mother of the petitioner died prior to, my lord, date of father, my lord. And my lord, kindly see, my lord, page 42, next of kins, my lord. It is 8 numbers of legal heirs, but the other, my lord, legal heirs, my lord, authorize the petitioner to file approach before this honorable court, my lord. And undertaking, my lord, authorization page 43.
No, all right, that's okay. This is
But-
only for he,
But, my lord,
even if you succeed, the money is not going to be paid to the petitioner.
my lord,
Now, you have to show that the petitioner was pensionable. He was entitled to receive pension.
but it regularized in the year 2005, my lord, and similar master role worker, my lord. Initially, my lord, the respondent, my lord, deduct 6 years of service, my lord.
Hmm.
And 20 years of service, my lord, to qualifying for pension, my lord. As per office memorandum, my lord, and rule 152 of Assam Service Pension Rules, my lord.
Where is Sanjita Rao's judgment?
Sanjita Rao judgment, my lord, kindly say, my lord.
It's 48 months.
48. And operative portion page 55. Paragraph 30. This honorable, my lord, declared the deduction of 6 years service and opined that, my lord, 20 years total qualifying service, 20 years service is required for getting pensionary benefit.
So which is the notification by which 6 years is deducted?
Deducted, my lord.
That has been struck down.
My lord.
Huh?
Yes,
That has been struck down.
Struck down, my lord.
First clause, 6 years clause is stuck down.
Okay, so there is no appeal against this order.
My lord. And
So
I,
therefore, no
Well,
deduction.
Yes, it's gone, your lordship.
So in this case, he was engaged in 1972.
my lord,
According to them, they are possibly.
No, according to the documents
Letters.
on record. So he retired in 2008. So this is obviously more than 20 years.
my lord.
Then why he will not be entitled to pension? Why?
My lord, I had filed my affidavit, my lord. My lord, because.
You tell us
Yes,
why he will not be entitled to pension.
Ye-
The deceased person, that's all.
Yes, my
You
lord.
file your affidavit, don't file your affidavit, file it twice, file it 5 times, that's another matter. Why would the petitioner's father not entitled to receive pension?
As per my lord, this order, my lord, that Sanjita Roy, my lord, he is eligible, but in the last 13 years, he have never approached before this honorable
Even
court.
if he doesn't approach for 130 years, if he is entitled to, you have to give it to him.
Yes, my lord.
You should have given it to him.
My lord, and as for pension, my lord,
Now
yes.
only argument is how much interest,
My lord.
No, my lord,
12% or 18%.
no, no.
Is it for the person to beg for his pension? He was entitled to
My
pension.
lord, when he was retired, there was no policy decision for pension, my lord. When petitioner father retired, my lord.
No, 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 no. After regular.
After that, my lord, this.
Some service pension. rule
Not by
applicable.
me. If both of you argue, not by me. Another court. Yes. Pastor.
Sorry, my lord.
My
No,
lord,
no, no.
I apologize,
I
my
don't
lord.
tolerate this.
My lord, I tender my apology, my lord.
That's all right, but not by me.
Public.
Lordship, my senior is on legs. Kindly pass over for time being.
This is what item 14 orders matter.
Yes, ma'am. Restoration, madam. They have filed for it.
We'll restore it.
Yes.
This was dismissed for non-prosecution.
Yes, ma'am.
Where is the order? Which page?
My lord, in
Lordship.
disposed of on 12/6/2023, my lord, in their
Page 11, Lordship. Aye.
Page 11. What is the matter about?
the matter is, my
Constitution of
lord, wearing of badge, my lord, in the BRO service, border road organization, my lord. They are, as per them, my lord, they are entitled for badge, my lord. 3, 4 badge, there is some badge, there is some government policy and on that matter is regarding wearing of badge from BRO.
So this is a 2011 matter. On number of occasions the petitioner was absent.
Yes,
So why it should be restored then?
my lord, we have filed our objection also, my lord. They're pleased that they.
Who is a senior?
Lordship,
Arm-
R. Mohinder, sir.
Let him come, we'll
Yes,
dismiss
my
it.
Nice, Lordship. Lordship, item number 15 also pass over. Sir.
Evidence of other demand, 15 hearing matter, my lord.
Hmm.
On 30, my lord, Tuesday or.
So what has happened? Some solution has been
No,
worked
my lord,
out.
that is in last time honorable court that for phrase hearing, my lord. Directed for phrase hearing.
15, you write, the petitioner's counsel prays for some accommodation on the ground that the arguing counsel, Mr. R. Majumdar, is currently not available. Ms. A. Gayan Lanet CGC has also prayed for deferring the hearing of this case to another date. In view of the above, registered to list this matter for hearing again on 15th of February 2024.
Master.
Right.
Ultimately, they have filed an affidavit.
Yes, what is the stand in the affidavit?
Your Lordship may see paragraph 7, my lord. Paragraph 7, the last part.
The affidavit is on record. Where is it? Yeah, it is. Paragraph 7.
Yes. Last part, your lordship can see. Further, the deponent begs to state that the respondent number 2 had inadvertently issued the appointment letter to the petitioner without getting financial approval from the finance department. Due to the inadvertent mistake committed by then respondent number 2, the deponent tendered his unconditional apology before the honorable court. Later on, after knowing the actual fact in regard to petitioner by office order dated 19/5/2023, our appointment was cancelled. As the petitioner is already recommended by the state level selection committee, so the petitioner will be appointed once the financial approval is received from the finance department. Now, my lord, the council of finance department is already there. Whether they have approved that or not, Mr. Nayak can say. I am told, my lord, when the SLP gives a recommendation, the member of finance also present there and they approve at the same time. Now, second time they want approval in the finance department.
Appointment on compassionate ground.
Yes, my lord.
What do you have to say, Mr. Nayak? After SLC, is there any further financial?
No, Lordship, there is a notification of 2012, Lordship. Their specific provision was there that for appointment to the grade 4 post, driver and teachers in the elementary school, prior approval of the finance department is necessary, Lordship. In this case, Lordship, probably I have not yet got received any instruction, but probably prior to getting the approval of the finance department, they issued the appointment letter. And subsequently, when they became aware that no such approval has yet been taken, they withdraw the appointment letter. That is the probably, situation, Lordship.
All right, we understand sometimes mistakes do happen.
Lordship.
But now what is the substantively, what is the position? Can you tell us?
Today, it may not be possible, Lordship. Lordship will grant me sometime, I will obtain instruction, Lordship.
By mistake, if they're given the order,
Probably,
that will not
probably.
create a right.
Because that
Yes,
OM is there.
Only one thing your lordship kindly see. They have
They've
said,
admitted it.
they have said they have cancelled my, but they haven't cancelled. They have taken my appointment letter,
Whatever
saying
it is.
that there is need some correction.
Whatever it is, somebody has made a mistake.
Well, that is, I
If
understand.
there is no approval, then there can't be appointment.
My lord, they can look
Your
into
client
that.
will not get salary.
My
What is
lord,
the point in such appointment?
of course, my lord, I cannot say exactly what has happened, but let them come with the
Finance is a
instruction.
party here.
Yes.
Yes, Lordship. As per number 1.
Then let us issue notice and see.
Lordship.
Yes, I think, my lord, within a week possibly my learned friend can get it.
Notice
Or-
has already been issued.
Notice already been given. My lord. Your lordship may
So
give
we'll
a,
post it after 10 days then,
my lord.
After 2 weeks, Lordship.
after 2 weeks.
I know some
Alright.
pressures are there.
Heard Mr. S. Dattalanik, Senior Counsel for the petitioner, also heard Mr. R.M. Das Lanet, SC Water Resources Department, who submits that in terms of the order dated 24/1/2024 passed by this court, the affidavit of the respondent number 4 has been brought on record this morning. I have perused the same. It appears that awaiting approval of the finance department, the order of appointment earlier issued to the petitioner has been withdrawn by the authorities. Mr. P. Nayak landed SC Finance 2 weeks time to obtain instruction and appraise this court as to whether finance approval for appointment of the petitioner as per the SLSC recommendation is under process and the progress made in respect thereof till date. Full stop. List this case again after 2 weeks as a fixed date.
My lord, only thing, my lord, I want to highlight that regarding the factual aspect of the matter, that they haven't withdrawn it. My lord, they have just taken.
No, no, Mr. See, the points are matter is very simple.
Man.
There is a SLC recommendation.
Man.
This recommendation has to be given effect to, but there is a procedure to do it.
Yes, yes, very correct.
So while giving effect to it, somehow somebody through oversight ignored a particular.
occur, yes.
So realizing their mistake, they have taken it back. And now they are awaiting the approval of the finance
My
department.
lord, they very fine, my lord. My lord, they could have said it in writing even, if it is a fact, but they did not do it. Only thing, your lordship, kind enough to pass an order yesterday, and they have filed the affidavit. Otherwise, they are sitting with the matter since August.
Now let us see, let Mr. Nayak.
Yes, sir.
After 2 weeks, Lordship.
It is a SLC recommendation. So I
She
don't
has
see
to be,
much.
she has to be appointed, Lordship. Only that approval of the authority, Lordship. That much only, Lordship.
So
Then
what
they
happens is, these are marginalized people. Some priority in these matters is what the court
I understood.
would always expect.
Yes, Lord.
Sometimes there are many issues which are of luxurious nature.
Lordship.
They are a little here and there is understandable. But for the common, the poor section of the, if we can't help them, what is the point?
Lordship, I
So
will
I'll
convey
request
the
you to-
concern of the court. Yes,
Yes.
Lordship. Yes, Lord. Obliged.
Much obliged.
May plead your lordship. Lordship, kindly peruse last order, 23/11, lordship.
Yes, have you got the records?
No, my lord, I have not received any record, my lord. Earlier occasion, Goswami was there, my part of matter. But I asked him, my lord, he has not received the record. He told me that you do the, yes. Let it be fixed, my lord, another date, my lord, I would try to obtain it.
But already time has been granted.
Already
These are
granted.
poor old matters.
Only affidavit I have seen, my lord, or affidavit they have filed.
Have they stated on affidavit that the records are missing?
No,
No,
lordship.
no, that is not so.
Then either produce the record or by the next date, let an affidavit be filed.
No record.
Hmm.
Still,
Who will file the affidavit?
Deputy Commissioner.
Huh?
Deputy Commissioner. Deputy Commissioner.
Yes,
Golaghat.
number 2.
That is the way forward, perhaps.
Yes, lordship.
That must be very learned counsel for the petitioner in both these petitions. Also have Mr. Additional Senior Government Advocate Assam appearing for this case submits that in spite of written communication made to the authorities, the records have not been sent since those are still untraceable. First up, Mr. S. Banik, learned counsel, is present on behalf of FPTC. The respond number?
4 and 5 in the first one.
Learned Counsel for the APTCL is present on behalf of the respondent numbers 4 and 5. And Ms. G. Hazarika, Learned Standing Counsel, Revenue Department, Assam, for the official respondent. Since records would be of vital importance for a decision of the controversy involved in this writ petitions, on the request of Mr. Chutia, 6 weeks further time is granted to the Learned Departmental Counsel to obtain the records. It is made clear that if the records are not made available on or before the next date fixed, the respondent number 2, that is the Deputy Commissioner of Golaghat, would file an affidavit stating the reasons for not being able to comply with the court's order, so as to facilitate final hearing of the writ petition. Let these writ petitions be listed again on 12th of March 2024. Copy of this order be furnished to Mr. Chutia during the course of the day. Ultimately, no copy will be given.
Yes, yes,
yes.
Lord, I apologize, I was on this. Lord, a restoration, my lord.
Nothing to restore.
My lord.
Let this rest in peace now.
No, my lord,
What is this wearing badge?
my lord, the similar repetitions, 2 other repetitions which were tagged together, they've been allowed, my lord, that censure was taken away. Therefore, my lord, that man does not have any further stigma in his career. But the other 2, my lord, lordship has granted the relief. Here, my lord, what had happened is I was given 3 wakalatnamas. I did not file one for them. It was total my mistake, and therefore I did not appear on the particular date
Where
for
are the
that
judgments?
petition, my lord.
Let's see the judgment.
My lord, yes, my lord.
Is it covered by the?
Yeah, exactly covered. The same disciplinary proceeding, the same punishment given to all of them. Everything remained the same. 3 repetitions. I did not file a wakalatnama in one of them. I misplaced it. And therefore, that I did not appear on that particular day. It got dismissed for non-prosecution. There were 3 repetitions, my lord. They were allowed only removing the censure.
All right, heard Mr. R. Majumdar, Learned Counsel for the applicant, also heard Ms. A. Gayal, Learned CGC, appearing for the opposite parties. This IA has been filed with a prayer to restore WPC number
5638 of 11.
5638/2011 to its original file by setting aside the order dated, by recalling the order dated 12/6/2023, by means of which the aforesaid writ petition was dismissed for non-prosecution. Full stop. By producing a copy of the order dated 14/6/2023, passed by this court in WPC number 5648/2011, Mr. Majumdar submits that the case of his client is covered by the said order passed in an identical writ petition, wherein similar order of censure was assailed by the writ petitioner therein. However, due to oversight and a mistake on the part of the counsel to tag the wakalatnama with the relevant record, the petitioner went unrepresented on 12/6/2023, leading to dismissal of the writ petition for non-prosecution. Mr. Majumdar submits that if the writ petition is not restored to its file and disposed of by granting similar relief to the petitioner hearing, applicant petitioner hearing, the same would lead to travesty of justice. Ms. A. Gayan has relied upon the counter affidavit filed by the department to submit that no good ground for restoration of the IA has been made out by the petitioner. After hearing the submissions of Learned Counsel for both the sides and on perusal of the relevant record, this court is not convinced with the explanation furnished by the Learned Counsel for the applicant. However, taking note of the fact that similar writ petitions filed by similar writ petitions praying for identical relief filed by similarly situated petitioners have already been allowed by this court. Full stop. Court, comma. Denying such relief to the applicant herein, in the opinion of this court, would lead to miscarriage of justice. As such, for ends of justice, the prayer made in this IS stands allowed. In this case of it, IN or in this case stands allowed. The order dated so-and-so is accordingly recalled. Registry to restore the writ petition to its original file and list for orders after 10 days.
I'm obliged.
By reflecting the name of learned counsel for the parties in the court list.
I'm obliged.
Please, your lordship. Lordship, I am paying on behalf of my senior for pass over this matter for today, lordship. He is not available for his personal difficulties, lordship.
Who is a senior?
J.K. Goswami, standing counsel, Apex Bank.
These are 2014 matters.
Lordship.
You do it.
Lordship, I am not.
Huh?
I'm not prepared, Lordship.
You're not a lawyer.
I'm not prepared.
Oh, you're not prepared. Sometimes people say I'm not a lawyer. Out of nervousness, maybe. Yeah, Mr. Kotagi, what is to be done?
In absence.
Can it be decided in his absence?
No, it's a service.
Mr. S. Kotagi, learned counsel is present for the petitioner on the request of learned counsel for the respondent, who submits that the arguing counsel could not come to court due to personal difficulties. Hearing of this matter stands adjourned for 3 weeks. Listed.
Obliged, lordship.
19.
Here the petition is aggrieved by the rejection of his candidature in a selection process, madam. The only ground for rejecting the candidature was that he was not certified to be a regular, to have undergone a regular course of study is kind of the respondents. The petitioner, my lord, if the advertisement is taken up, under which the petitioner had participated at annexure 3, page 31. Page 32 is relevant, madam. Page 31.
1 minute. Mr. Majumdar, just take your seat for a minute. what is there? This recruitment process has not been concluded.
There is no
2013,
interim-
14, huh?
It has been concluded,
It
my
has
lord. There is
been
no
concluded.
interim order.
Then what is the,
But,
what
if it-
remains in this case?
My
now?
lord, the selected candidate has been made a party, my lord.
Hmm.
Selected candidate has also been made a party, my lord, and he was represented, my lord. Now,
Correct. What is the relief?
subject to outcome is there, my lord. The subject to outcome of the repetition will be there, my lord. Because,
So
my lord,
supposing the court holds that it was a recognized degree, then what is the relief? That
my lord, then I would have an opportunity to sit in the interview which
Hmm.
they will have to conduct. Now, if I sit in the interview, lordship will kindly see, my written marks are far higher than the person who has been selected for the.
But where is he working now?
My lord, who, my lord?
Petitioner?
The petitioner is doing petty jobs, my lord, in private jobs, my lord. He's not working as such under the IOC. He's in a petty job, my lord. Now, the only ground on which they have rejected the candidature, initially they tell me that the course is not regular. Once I show them that the course is regular, they say you are not a regular student. Now, the condition of being a regular student and what it would mean has already been clarified in their advertisements itself. He having been deprived, my lord, this is the second round of litigation.
We
on
will
this
not
matter, my
set
lord.
aside the appointment of the private respondent after 10 years. This will be highly
But my
inequitable.
lord, if
Some orders are not practically
I understand,
practicable.
but if I, my lord, if I
You take your time, make your submissions.
No, no.
I have told you the order that will be passed.
my still
Not
my prayer
possible.
would be
After
if-
10 years, you can't throw out him and then ask them to reconduct the interview, which would have been done in 2013. These matters are gone.
he challenged it at the appropriate time.
We'll
my lord.
explain that this is not practicable, so we'll not.
There have been orders of the court, my lord, if the candidate is found to have been entitled to the selection, then they would accommodate him without perhaps disturbing the other person. It is not that they would not have posed.
No, how? Because you see, you are yet to, the vivacy, you have not appeared.
That is the time.
The
when I came up-
vivacy, what will be the outcome, nobody knows.
My lord, if the vivavacy, if I fail in the vivavacy, if they make me fail in the vivavacy, I would have little to say. But the rejection of the candidature, the manner in which it was done is the concern, my lord. If today, my lord, if that step can be taken tomorrow, someone will be rejected and he would not have a chance. My lord, they lose out.
The way out is to stall the process and get an early disposal. No other way.
My lord, the writ petition, when it was initially filed, I was asked to file a representation before them, which I did. And when they rejected it, by the time the appointment was made, and
That's right.
therefore I had made him a party also. And I have done, my lord, the petitioner has done what he could at the earliest point of time. He has not stalled it for a day also, my lord. And perhaps, my lord, if I remember correctly, there is an order in which there is, it has been made subject to outcome of the writ petition. But the respondent has been served.
Mr. Majumdar,
He has not come
you
to fight
make
it out.
your arguments,
No, no.
I'll hear you. But this court will not set aside the appointment of the other respondent. Question doesn't arise. After 10 years, just because something went wrong here and there, we cannot disturb the life of another person.
My lord, that has been also.
This is a completely
Lordship, if they come- And
impact.
may I pray for some time, my lord, if I can show lordship to some extent that without disturbing the respondent, I would still have a right to claim for an appointment or for an adjustment. Perhaps lordship would consider that lordship will give me some time on that, man. Otherwise, my lord, I can show that if I have a case. Now, the relief part, my lord, is what the petitioner is actually interested in, all petitioners. If lordship will give me some time, I'll try to find out some law which would say, Gaurav Pradhan is one I remember offhand, which said that, yes, they had a right.
No,
Don't
Gaurav
disturb.
Pradhan decision says, Supreme Court says, create a superannuation post.
If required.
But here you are not selected. In that case, those people were found to be entitled to appointment.
Yes.
You are not entitled to
My
appointment.
lord, here,
You have been plucked out of the selection
my lord,
process.
that is why I was not
You
placing
will
Gaurav.
be back to the selection process, but that is already over.
My lord, that is the exact reason I was not placing Gaurav Pradhan on the first, my lord. If I can find something which will suit this person, my lord.
Do it.
I'll
You are
try, my lord,
entitled to,
get
but
some relief, my lord.
it's not possible. It's not possible. Some things you have to let go of. Not possible.
The delay.
And even there are ways to write out an order also saying here. Because you see, we are not here to comment on what order you should ask for and what orders the court should give.
My lord.
But you missed the bus when you accepted that order. Representation. It's over. That is the day you lost the case. Nothing could have been done after that. Because the person was appointed when there was no interim order, nothing. Was there any order that till the representation is decided, no appointment will be made?
I'll have to go through the earlier petitions order.
Then
Lordship will give me some time.
Yes, Mr. Bharat. You want it to be listed before some other court?
Leave it to lordship, my lord. I'm comfortable everywhere, my lord. I need to leave it to lord. It's what I can argue is what I will argue, my lord. It's not order that
Yes, but
I
you see,
fear.
it doesn't take us very long to understand what is what. Sometimes the council may feel that the court is reacting too early.
No, at
But
least
then at the end of the day, after half an hour, the same reaction will come because I can see through what has happened here. There is no order saying that till the representation is
there's
disposed
no
of,
such order, perhaps.
further proceeding in this election has to be stalled. So you have lost the case on that day, which I was hesitant to say that. You thought you won it. You means your petition, your client, but you had actually missed the bus on that day. Not lost the case, but you missed the bus. Once these things are sent, what is there to dispose of a representation? He is challenging the decision of the authorities holding that this is not a valid degree. The court has to answer that this is valid or say it is not valid. What is there for them to again examine the representation? They have already said it's not valid. You understand? So that order was against you. After 2 weeks, on the prayer of Mr. R. Majumdar, Learned Counsel for the list this case for hearing again after 2 weeks. Mr. P. Varadar, Learned Counsel is present for that. Have you followed what I'm saying?
I got it.
So by legal fiction, it cannot be reached. You cannot extend it to that. Secondly, a person who has been working since last 10 years, how can the court throw him out for no fault of his own? He is now a settled person. I don't know whether he or she, he must be having a family. He must have grown in the organization. He cannot be disturbed. So be prepared after 2 weeks. Only submission you may make is released before another court on that day.
That I have not done till today, my lord. I'll try not to have it done.
Or convince the court that what is being said, there is another angle to it. I mean, you see, you can take long time. These matters can be heard for half a day, but it is sheer wastage of judicial time. That's why I don't do it.
Lordship will perhaps appreciate when something falls from lordship. I try to find out one answer to that. If I don't have it, I will tell the court. If I have it, then I'll try to
find out. And again, I am putting it back again. When he came to the court in 2013, he raised a very valid question. That question might be answered in his favor, might be answered against him. But he raised a question.
Yes.
That is a question which, with all respect to the learned judge, ought to have been answered by the court, this way, that way. Once they say that you are not valid, again sending it to them to answer whether you are valid or not, perhaps does not make any sense. But that order was not clothed with a rider that till you decide or give an opinion, don't take any step. So while they went on with the representation, they also concluded the process. And that is how a third party right has been created. So I don't know where, whom, but then your client has missed the bus. Now the clock cannot be set back merely because one argument made by Mr. Majumdar is very attractive. His arguments are usually very attractive, but the clock cannot be set back. Take your chance. 2 weeks. Yes.
Pass off the matter for time being.
Pass over the matter for
Time being.
time being. The last item.
My seniors on legs,
Is this the last item? One more.
Lordship, it's a termination of contractual employee, my lord. Lordship has already fixed some matters on 8/2, my lord. Lordship can fix this on 8/2 on same day, my lord. Because termination of contractual employee, my lord.
All right, then 8/2. Yes.
Obliged.
List again on 8/2. On the request of the Learned Department Council, list this matter again on 8/2.
Obliged.
Petitioner's counsel is present.
I beg to appear for the respondent number 2, 3, and 4.
Pertains to excess recovery.
Sorry?
Recovery of excess dwell. Matter pertains.
Yes. What are the facts?
Yes, ma'am. Petitioner, my lord, he was working in an organization called, my lord, EPIL, my lord.
And he he resigned, my lord, and thereafter there was a interview calling for the ex-employees of the organization, my lord. Then he appeared and he was selected in the interview and he was posted as a AGM of the organization. Now, my lord, if comes to page 20 of the petition.
Just 1 minute, Mr. Miller.
My
Yes.
After retirement, resigning, my lord, there was an interview calling for the ex-employees of the organization.
Come to the point. What
I'm
is the
sorry,
point?
also.
Yes.
The page 20, my lord, it says, my lord, the petitioner, he resigned from the services of the company and was relieved on so-and-so date in the year 2009. At the time of release, he was drawing a basic salary of 4.
Oh, why don't you start from when he was born and when he went to his kindergarten school? Come to the point, which is
Mine.
your subject matter challenge. Which order are you challenging?
At page 44, my lord.
Yes.
By this order, my lord, his basic pay was refixed on 27 January 2023. May I read it, my lord?
Yes, yes.
With reference to the above subject, it is informed that you have been appointed as an additional general manager at the level of E6 in the pay scale of so-and-so with effect from, as observed by CAG audit wide half margin number 16 dated so-and-so, you have been drawing the basic pay of 41530 in place of 36600 with effect from so-and-so. However, as per the pay fixation rule of the EPI on initial appointment and as per DPE OMs in this regard, your basic pay should have been fixed at a minimum of pay scale that is 3600 in place of 4153. Initially, his basic pay was 4153030, but now it has been reduced to 36600. Accordingly, in order to comply with the CAG audit's observation in line with the clause 9 on the pay fixation and the initial appointment of EPI recruitment policy and the DPM OMs in this regard, your basic pay is refixed at to so-and-so as on 1/1/2023. The date of your next increment will be.
So, do you agree with this, that your pay was earlier fixed wrongly?
No, my lord. He was earlier working for the EPI, my lord. Then he resigned.
Your earlier, as they are saying, your pay fixation earlier was wrongly made, erroneously made.
No, my lord, because, my lord, why I'm saying, before, at the time of resigning from the company, my lord, his basic pay was 41530. Then when he resigned again after the interview, he was been given the same salary, same basic pay of 41530. Now they have come with an in their affidavit in opposition. They have come.
Where is his appointment order?
Page 24, my lord. In pursuance to interview held on 19 September 2011 at Corporate Office, New Delhi, we are pleased to offer you the post of Additional General Manager in IDA scale of pay 3600 to 62000 at EPS terms and conditions applicable to the proposed class of employees. So you may join. That is the.
This was pursuant to some advertisement.
Yes, ma'am. Advertisement.
Where is it on record? Advertisement?
Well, that is on record. I can provide your lordship.
So you resigned from your earlier post. You were
Yes.
earlier working as?
But page 20, my lord, can be seen. He was working last as deputy general manager.
So he was working in the EPI only.
EPI itself. Then he resigned. Then there was an interview call that is before your lordship for the ex-employees. He again joined my lord after successfully completing the interview. Then he was offered this, my lord, offer letter at 24, page 24. And he was receiving at the time of resigning from the company, my lord. The basic pay was 415,300. That it will be evident from page 20, my lord. Page 20. Petitioner resigned from the Secretary of Government and was relieved. He was drawing the basic pay of rupees 41530.
All right.
So he was under the impression that the same basic pay would be continuing. So that continued, my lord. And in thereafter, my lord, by order dated 27/1/2023, his basic pay was decreased, refixed, my lord. Thereafter, the amount which has been given in excess was sought to be recovered, my lord, by order dated 28/4/2023 at page, my lord, 58. Now, this is not because of some misrepresentation or fraud on the part of the petitioner. It is because of some mistake.
You are challenging the recovery or refixation?
Both, my lord. Because the refixation order was passed without giving an opportunity of hearing to the petitioner, and further, my lord, the OM that they are relying, my lord, that does not apply to the petitioner, my lord. The OM is dated 14/12/2012. And
You are appearing for whom?
I am appearing for the company. Just for number 2, 3, and 4.
Why don't you give him a hearing and then take
My lord, if your lordship kindly, what case they are made out, what they are asking for is pay protection. Now, my lord, the petitioner was engaged in the company in the year 1989 and
on merit, then we'll hear. But I am asking you, since you see there are issues here, you may have your projections which you are entitled to. But the point is, he resigned in the same organization in a lower post. And then he joins on an open selection in a higher post. So you're right. I was about to say this.
that is why I want to point out the dates, my lord. He
But
was
you
in private employee.
don't want to give him a hearing also?
My lord, this entire order was passed pursuant to a CAG audit report, my lord. If your lordship wants, take a look of that, my lord, at page 62 of
But
my.
why don't you hear what his version is?
Because, my lord, as per CAG, my lord, upon going through everything, my lord, 2 things were found. His appointment was also irregular and he was not entitled to any pay protection. And everywhere in the appointment letter, as well as the offer letter, the pay grade was mentioned as IDA 33,600 to 62,000. Now, as per rule, he has to be put in the lowest grade. But he was.
Just a minute. If it is to be heard, we'll hear it. There is no problem. I just wanted to, you are Mr.
Arnav Chakraborty.
Mr. Chakraborty. See, there are only 2 things. I'm pointing it out to you. You are free to agree or disagree, and I understand you are holding a brief. There is no difficulty with that. This, for him, is almost like a major penalty, reduction of pay scale, almost like it. You may have your own logic, but the fact is that he was given a pay scale which has been sought to be brought down. So The process is different, but the effect is same to the employee, that his pay scale is being lowered, right? So whatever arguments you may have, why don't you hear him once? This is what we are saying. And secondly, the law of limitations will have its role. Even
Milord,
if
on that,
CSD
Milord, I have an answer, Milord. Milord, if your lordship sees the scheme of law of limitation, Milord, law of limitation only bars a remedy, but doesn't extinguish the right. If I can establish before your lordship that whatever he was getting, that was by way of a mistake, whether that he has a contribution or not, that is Milord a separate aspect, I will deal with that. But mistake cannot confer any right. And if there is no breach of right, Milord, that cannot, Milord, come under Milord jurisdiction. And secondly, Milord, limitation, Milord, had I been gone to a court of law for enforcing my right, then that is barred. Milord, it is a settled law. If your lordship sees this in section 3 also.
So, supposing
Remedy barred.
Mr. X takes a loan from the bank, bank sits tight for 3 years, and then it can issue a demand notice to recover the amount after
Milord,
3 years.
if the bank, Milord, to my respectful submission was subject to correction by your lordship, Milord, if the bank owners goes to the surface court for enforcing that thing, he cannot go because it is barred by law, and his remedy is also barred.
But he can take it in his own hand.
But if there is some continuing relation and the money is lying with a person, he has a lien over that money, then, my lord, it is not a matter of enforcing my right by way of any litigation. So I am not going for any remedy, initiating any remedy. But it is settled, I can show from the case law.
All right, but
the right cannot be extinguished. Right exists.
Company is not
He is
willing to hear him, give him an opportunity of being heard.
Lord, that I have to take, Lord, instruction, Lord, because it was done pursuant to a CAG audit. And CAG has.
No, you take your stand. CAG, everything is done. CAG's job is to do audit. This is not
Yes,
news.
Lord.
This is not a breaking news that CAG
No,
is done.
no, Lord, it is not a.
CAG's job is to do audit. CAG has its own point, but that is not final and absolute. Correct. This is also subject to review, scrutiny at whatever level.
That I can understand, Lord. On that, I have.
Here the point is, for whatever right, wrong reason, this person has been given a pay scale and physically the amount has been transferred to him. You want to take it away with retrospective effect. According to you, since CAG has pointed out, that is a mistake. He says it's not a mistake. You are not willing to hear him.
Milord, the
Very
difficult, Milord, no, it's not that, Milord, I have to take instruction on that. The difficulty, I am telling you, the practical difficulty. Your lordship knows that the person is going to retire in the month of June. Now, Milord, a recovery order during the last year of his appointment cannot be made, Milord. If I give him today, Milord, whatever grounds I have for recovery, whatever grounds he has for challenging, assailing that order, Milord, that is before your lordship by way of affidavits. Now, today, if I go back and give him a chance of hearing, Milord, obviously, if your lordship wants, I will take an instruction also. But as far as I recollect, Milord, from the rules, Milord, in the last year of that will be barred, Milord. That cannot be recovered. The order was passed prior to 1 year.
No, that provisions we can make in the court order. That since this will be done as per a court order.
In that event, Milord,
not come into
in that event, Milord, I'll take over.
because we don't know what is there. If he is able to point out in writing that these are the issues.
Yes, Milord, whatever grounds he has put in affidavit, Milord. Today also, Milord, the grounds are there. That will be agitated, Milord. If your lordship wants, Milord, that hearing, Milord.
All right, then we'll hear and pass a judgment.
But if your lordship wants, Milord, if your lordship gives a protection
No,
that even for the last year.
It's up to you. He says that it has been done without hearing my version.
Yes, I know that is a challenge I have to face.
In a court setup,
yes,
this kind of matters. This is a argument.
Lord, let me take an instruction and come back before your lordship.
But if you want to go ahead with the hearing also, there's no problem.
If your lordship kindly protect me to that extent that the last year's clause, since it is the last year, that will not come into the way, my lord.
Of course.
Then, my lord,
court is not only interested in him.
Yes, my lord. Ultimately, justice to people. He should not get in by mistake, my lord. He should not get, my lord, money extra from public exchequer, my lord. That is also.
That is important.
Yes,
But we are more concerned about the fairness of the process.
absolutely, no,
If
absolutely.
a
We are
litigant
all-
comes and complains that very unfairly I've been, how can the courts, what else the courts are required to do? The primary job of the court is to see that everybody gets a fair treatment. So whatever be your reason, you are certainly coming up with a stance which is adverse to interest of a person. How can you say that we'll not give you an opportunity of?
No, I'm not
That
at all.
is an argument the court will always find very difficult to.
No, I have the point of natural justice, my lord. That is,
Yes,
it has a civil consequence. It has a civil, I can appreciate. No, my lord, let me come back on that point, my lord. Because the company was, my lord, in my view, it is my personal view, not a thing. He has not touched the appointment procedure. His application was submitted after the scheduled date of interview. No application could be recorded. Everything there is, my lord, gray area everywhere, my lord, in the course of appointment also. With that, as it may, my lord, I'll not come back with that instruction, my lord. Whatever is falling for me, lordship, my lord, I bow down to that, and it is quite fair thing, my lord.
His appointment procedure is not the subject matter of this proceeding.
No,
Or
no, I'm
even-
not.
Even your interim.
That has not been done, my lord.
The
Only
issue
thing,
here
only
is-
for the last 5 years, whatever extra amount has been paid, that has sought to be recovered. No, he is getting money from 2011.
Correct.
But we are only, my lord, recovering last 5 years, nothing else. Only last 5 years. Even whatever extra he has get during 2011 to, my lord, 2018 or 17, that has not been touched also. Considering the,
You are an outstation counsel.
yes, my lord, from Calcutta.
If you want, we can give you 5 minutes.
Lord, I don't think that this decision can be taken in 5 minutes, my lord. I'll come back.
Okay. But please don't feel constrained. You can also.
No, my lord,
argue,
I have,
if you want.
whatever,
But
my lord.
I felt that I should point it out to you.
Yes, my lord.
This is an aspect the court will deal with it, even if the matter is argued.
Yes, my lord.
Because effectively it is almost a major penalty of reduction of pay scale for him. The procedure could be different. The reasons can be different. It's not on misconduct.
It's not on misconduct or
It's not on
imposing
misconduct.
penalty by mistake,
But-
recovery and mistake.
In effect, it is the same thing for him.
It has a civil consequence.
Civil consequence. So this has been the fundamental tenet of law in a civilized society, that if you do it voluntarily, then we'll think of the order of protection. Otherwise, on merit,
No, no,
whatever happens, happens.
I have understood.
Either
Whatever,
the petition will be dismissed or allowed, but then there is no question of any protection
yes, my lord, that I understand.
to either side. So what do you want? You want the court to defer it?
Yes, my lord.
Till when? This suggests you are coming from outstation, so there is an interim order in your favor.
Fine.
Mr. Mani. Then
He is enjoying that.
can both of you agree on a date?
As per his convenience. Yes, my lord.
Yes, as per your convenience.
Can it be on, my lord, 22nd or 23rd February, subject to your lordship
All right.
convenience? Okay.
Please choose one date, please. Either 22nd.
Any day which is convenient. I'm
22nd
Thursday.
is a Thursday. That suits you?
Yes, my lord.
All right. Had Mr. P.K. Manil and counsel appearing for the writ petitioner during the course of arguments. Also had Mr. A. Chakravarti and counsel appearing for the respondent number 1. Full stop. Now you are for respondent numbers
2, 3 and 4.
Ms. K. Fukul and CGC has appeared for respondent number 1. During the course of argument, certain issues arose in this case, for which the learned counsel for the respondent has sought, respondent numbers 2 to 4 has sought some time to obtain instruction. In view of the above and on the request of Mr. Chakravarti, learned counsel for the respondent numbers 2 to 4, list this case again on 22/2/2022 as a fixed item for hearing.
Deeply
May I pray one thing? As the appointment has been questioned, my lord, I have the.
Appointment has not been questioned.
No, it is not.
He is only saying that this is the backdrop.
Yes, there is a minutes, my lord, for the interview conducted. Can that be produced, my lord? If that is produced, my lord, everything will be
No,
clear.
that is not the subject matter.
That's not the subject matter. Your case is only about altering refixation and recovery.
Yes.
We'll only confine to that. There's no other proceeding about anything else. You broaden it, you will be in trouble, Mr. Munir.
No.
Let's
Fine.
not extend it beyond that. We are only on the question
Fine.
of the principles
Fine.
which were followed by the
Yes.
or not followed by the department in initiating the action. Otherwise, They are entitled to, if it is
Fine.
wrongly done, then why will they not? Suppose the only only argument would be limitations,
Yes.
which is not your pleaded case. You have not even taken that plea. Correct?
Only, my lord,
You have not even taken that plea.
yes.
Whereas that is the biggest plea. Rafiq Masih's entire judgment is premised on this fundamental principle that all these actions should have a time limit.
Yes.
That is the.
That we have.
So
got it.
where is the time limit argument? You have not even taken it. You are saying it is about state of Punjab versus. But that was a case where Supreme Court says, in case of this category of employees or somebody who has
Quite
gone
right.
on retirement.
No, that is one of the situation.
Yes.
One of the situation.
What is the
Yes,
situation like your client's case? What is the bar? Rafiq Masih does not create a bar.
Well, it says, my lord, if the anomaly is detected after 5 years, then it is inquitous.
That's limitation.
Yes.
You have not taken that plea.
Well, we have, well, that is there. I'll
Alright,
so
we'll
it
see.
bring it to your lordship. That is why we are only recovering 5 years, not beyond that.
All right. So the expressions could be different, but yes, that is relevant because you can digest bank's money also if it is barred by limitation. Nothing can be done. But we'll see that. But right now, your
Yes,
instruction is only to the point that
If I
the
hear it,
interim order will continue till his representation is considered and heard and a reasoned order is passed. Whatever be the outcome, this will not come in the way of or create any obstruction for implementation of any of the provisions of the rules applicable to a retired employee. This is the order will pass.
Yes.
If both sides agree, otherwise we'll hear and give a judgment.